systems rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice
based upon gender to influence your decisions. You must also not any witness or any other party based on any identifying characteristics such as race, religion, age, gender, gender identity, gender expression, sexual orientation, ethnicity, national origin, disability, socioeconomic status, or any such characteristic. You must not allow bias to influence your verdict. Remember that you must also guard against unconscious bias, also called implicit bias. Unconscious biases are stereotypes, perceptions, attitudes, or preferences that people may hold without being aware of them. Such biases can affect how we evaluate information and make decisions. You must not allow unconscious bias to influence your verdict. One way to guard against unconscious bias is to ask yourself during your deliberations whether your views and conclusions would be different if the defendant or the witness were of a different race, religion, age, gender, gender identity, gender expression, sexual orientation, ethnicity, national origin, disability, socioeconomic status, or any other such characteristic. If the answer is yes, then you should reconsider your views and conclusions along with the other jurors and make sure that your decision is based on the evidence and not on any such stereotypes, perceptions, attitudes, or preferences. If you decide that the prosecution has proved beyond a reasonable doubt that Mr. Alissa is guilty and that he was sane, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. Finally, you should consider all the evidence in light of your experiences in life. The charges against Mr. Alissa are not evidence. The charges against Mr. Alissa are just accusations. The fact that Mr. Alissa has been accused is not evidence that Mr. Alissa committed any crime. Mr. Alissa is charged with committing the crimes of murder in the first degree, 10 counts, attempted murder in the first degree, 38 counts, assault in the first degree, a single count, and possessing a large capacity magazine, 6 counts, in Boulder County, Colorado, on or about the date March 22nd, 2021. Mr. Alissa has pleaded not guilty by reason of insanity. Every person charged with a crime is presumed innocent, including a person such as Mr. Alissa, who has pleaded not guilty by reason of insanity. The presumption of innocence remains with Mr. Alissa throughout the trial and into deliberations. This presumption of innocence remains with Mr. Alissa throughout the trial and should be given effect by you unless, after considering all of the evidence, you are then convinced that Mr. Alissa is guilty and that he was sane beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. This includes a duty to disprove Mr. Alissa's insanity beyond a reasonable doubt. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt and that Mr. Alissa was sane, you should find Mr. Alissa guilty of that crime. If you find from the evidence that the prosecution has failed to prove any one or more of the elements of a crime beyond a reasonable doubt, you should find Mr. Alissa not guilty of that crime. Insanity is an affirmative defense. The prosecution must prove Mr. Alissa's guilt beyond a reasonable doubt as to the affirmative defense, as well as to all elements of the crime charged. If the jury is not convinced beyond a reasonable doubt of Mr. Alissa's guilt and sanity after considering the evidence of the affirmative defense and all other evidence, you must return a not guilty verdict. Every criminal defendant is presumed sane, but once any evidence of insanity is introduced at trial, the burden of proof is on the government to prove sanity beyond a reasonable doubt. In this case, a separate offense is charged against Mr. Alissa in each count of the information. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find Mr. Alissa guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense charged against Mr. Alissa. Mr. Alissa may be found guilty or not guilty of any one or all of the offenses charged. The number of witnesses testifying for or against a certain fact does not by itself prove or disprove that fact. You are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. During the trial, witnesses testified in a language other than English, which was then translated into English by an official interpreter. Although some of you may know the other language, it is important that all jurors consider the same evidence. Therefore, you must only consider the English translation as provided by the interpreter. You are not bound by the testimony of witnesses who have testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight you give the testimony is entirely your decision. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt or his sanity at the time of the offense, and cannot prejudice Mr. Alissa. It is not evidence. It does not prove anything and must not be considered for any purpose. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on firsthand observation of the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. The court admitted certain evidence for a limited purpose. At that time, you were instructed not to consider it for any purpose other than the limited purpose for which it was admitted. The credibility of a witness may be discredited by showing that the witness has been convicted of a felony. A previous conviction is one factor which you may consider in determining the credibility of the witness. You must determine the weight to be given to any prior conviction when considering the witness's credibility. In the following counts, Mr. Alissa is charged with murder in the first degree after deliberation of the following persons. Count 1, Nevin Stanisic. Count 2, Kevin Mahoney. Count 3, Trelana Bartkowiak. Count 4, Ricky Olds. Count 5, Denny Stong. Count 6, Lynn Murray. Count 7, Terry Leiker. Count 8, Jody Waters. And count 9, Suzanne Fountain. This instruction pertains to counts 1 through 9 of the complaint and information. The elements of the crime of murder in the first degree after deliberation are, number 1, that the defendant, number 2, in the state of Colorado, out or about the date and place charged, number 3, after deliberation, and 4, with the intent, number 5, to cause the death of a person other than himself, number 6, cause the death of that person or of another person, number 7, and that the defendant was not insane as defined in instruction number 32. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of murder in the first degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 6 beyond a reasonable doubt, you should find Mr. Alissa not guilty of murder in the first degree. If you find the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. In the following count, Mr. Alissa is charged with murder in the first degree, peace officer of the following person. Count 10, Eric Talley. This instruction pertains to count 10 of the complaint and information. The elements of the crime of murder in the first degree, peace officer, are, number 1, that the defendant, 2, in the state of Colorado, at or about the date and place charged, 3, after deliberation, and 4, with intent, 5, to cause the death of a person other than himself, 6, cause the death of that person or of another person, and number 7, the victim was a peace officer, firefighter, or emergency medical service provider engaged in the performance of his or her duties. And number 8, that the defendant was not insane as defined in instruction number 32. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of murder in the first degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of elements 1 through 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty of murder in the first degree. If you find the prosecution has failed to prove element 8 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. In the following counts, Mr. Alissa is charged with attempt to commit murder in the first degree, extreme indifference of the following persons. Count 11, Angela Peacock. Count 12, Casey Taylor. Count 13, Hayden Steele. Count 14, Kajendra Mala. Count 15, Jacqueline Keaton. Count 16, Paul Johnson. Count 17, Kimberly Breckus. Count 18, Micah Huang. Count 19, Tasia Beresford. Count 20, Patrick Cruz. Count 21, James Graham. Count 22, Kelly Ray Dorr. Count 24, Sarah Moonshadow. Count 26, Nick Edwards. Count 28, Christopher Tatum. This instruction pertains to counts 11 through 22, 24, 26, and 28 of the complaint and information. The elements of the crime of attempt to commit murder in the first degree, extreme indifference are, number one, that the defendant, two, in the state of Colorado, at or about the date and place charged, three, under circumstances evidencing an attitude of universal malice, manifesting extreme indifference to the value of human life generally. Number four, knowingly. Number five, engaged in conduct which created a grave risk of death to a person or persons other than himself. And six, engaged in conduct constituting a substantial step toward the commission of murder in the first degree, extreme indifference. Number seven, and that the defendant's conduct was not legally authorized by the affirmative defense of insanity as defined in instruction 32. A quote, substantial step, end quote, is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of criminal attempt to commit murder in the first degree, extreme indifference. After considering the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 6 beyond a reasonable doubt, you should find Mr. Alissa not guilty of criminal attempt to commit murder in the first degree, extreme indifference. If you find that the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. In the following counts, Mr. Alissa is charged with attempt to commit murder in the first degree after deliberation of the following persons. Count 23, Sarah Moonshadow. Count 25, Nick Edwards. Count 27, Christopher Tatum. This instruction pertains to counts 23, 25, and 27 of the complaint and information. The elements of the crime of attempt to commit murder in the first degree after deliberation are, number one, that the defendant, two, in the state of Colorado, at or about the date and place charged, three, after deliberation, and four, with the intent, five, to cause the death of a person other than himself, and six, engaged in conduct constituting a substantial step toward the commission of murder in the first degree after deliberation, and seven, that the defendant's conduct was not legally authorized by the affirmative defense of insanity as defined in instruction 32. A quote, substantial step, end quote, is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of criminal attempt to commit murder in the first degree after deliberation. After considering the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 6 beyond a reasonable doubt, you should find Mr. Alissa not guilty of criminal attempt to commit murder in the first degree after deliberation. If you find that the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. In the following counts, Mr. Alissa is charged with attempt to commit murder in the first degree, extreme indifference, peace officer of the following persons. Count 29, Brian Capobianco. Count 30, Pam Gignac. Count 32, Richard Stidell. Count 34, Brian Pleiter. Count 36, Alexander Casera. Count 38, Jenny Schmitz. Count 40, DJ Richard Smith. Count 42, Brian Capobianco. Count 44, Brandon Braun. Count 46, Michael West. Count 47, Jeffrey Brunkow. And count 48, Samuel Kilburn. This instruction pertains to counts 29, 30, 32, 34, 36, 38, 40, 42, 44, and 46 through 48 of the complaint and information. The elements of the crime of attempt to commit murder in the first degree, extreme indifference, peace officer are, number one, that the defendant, two, in the state of Colorado, at or about the date and place charged, 3, under circumstances evidencing an attitude of universal malice, manifesting extreme indifference to the value of human life generally. 4, knowingly. 5, engaged in conduct which created a grave risk of death to a person or persons other than himself. And 6, engaged in conduct constituting a substantial step toward the commission of murder in the first degree, extreme indifference, peace officer. 7, and that the defendant's conduct was not legally authorized by the affirmative defense of insanity as defined in Instruction 32. A quote, substantial step, end quote, is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of criminal attempt to commit murder in the first degree, extreme indifference, peace officer. After considering the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 6 beyond a reasonable doubt, you should find Mr. Alissa not guilty of criminal attempt to commit murder in the first degree, extreme indifference, peace officer. If you find that the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. In the following counts, Mr. Alissa is charged with attempt to commit murder in the first degree after deliberation, peace officer of the following persons. Count 31, Richard Steidel. Count 33, Brian Pleiter. Count 35, Alexander Casera. Count 37, Jenny Schmitz. Count 39, DJ Richard Smith. Count 41, Brian Capobianco. Count 43, Brandon Braun. And count 45, Michael West. This instruction pertains to counts 31, 33, 35, 37, 39, 41, 43, and 45 of the complaint and information. The elements of the crime of attempt to commit murder in the first degree after deliberation, peace officer are: 1, that the defendant; 2, in the state of Colorado at or about the date and place charged; 3, after deliberation; and 4, with the intent; 5, to cause the death of a person other than himself; and 6, engaged in conduct constituting a substantial step toward the commission of murder in the first degree after deliberation, peace officer; and 7, that the defendant's conduct was not legally authorized by the affirmative defense of insanity as defined in Instruction 32. A quote, substantial step, end quote, is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of the crime of criminal attempt to commit murder in the first degree after deliberation. After considering the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 6 beyond a reasonable doubt, you should find Mr. Alissa not guilty of criminal attempt to commit murder in the first degree after deliberation. If you find that the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. If you find Mr. Alissa not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find Mr. Alissa guilty of any of the attempt to commit murder in the first degree in counts 11 through 48, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Did Mr. Alissa use or possess and threaten to use a deadly weapon? Answer yes or no. Mr. Alissa used or possessed and threatened to use the use of a deadly weapon only if, 1, the defendant used or possessed and threatened the use of a deadly weapon; 2, during the commission of attempt to commit murder in the first degree or in the immediate flight therefrom. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all of the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. This instruction pertains to count 49, Ellen Schottky, of the complaint and information. The elements of the crime of assault in the first degree are: number one, that the defendant; number two, in the state of Colorado at or about the date and place charged; three, knowingly; four, under circumstances manifesting extreme indifference to the value of human life; five, engaged in conduct which created a grave risk of death to another person; and six, thereby caused serious bodily injury to Ellen Schottky, and that the defendant's conduct was not legally authorized by the affirmative defense of insanity as defined in Instruction 32. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of the crime of assault in the first degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 6 beyond a reasonable doubt, you should find Mr. Alissa not guilty of assault in the first degree. If you find the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. This instruction pertains to counts 50 through 55 of the complaint and information. The elements of the crime of possession of a large capacity magazine are: number one, that the defendant; two, in the state of Colorado at or about the date and place charged; three, possessed a large capacity magazine; four, and that the defendant's conduct was not legally authorized by the affirmative defense of insanity as defined in Instruction 32. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Mr. Alissa guilty of possession of a large capacity magazine. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements 1 through 3 beyond a reasonable doubt, you should find Mr. Alissa not guilty of possession of a large capacity magazine. If you find that the prosecution has failed to prove element 4 beyond a reasonable doubt, you should find Mr. Alissa not guilty by reason of insanity. If you find Mr. Alissa not guilty or not guilty by reason of insanity of possession of a large capacity magazine, you should disregard this instruction and fill out the verdict form reflecting your not guilty verdict. If, however, in counts 50 through 55, you find Mr. Alissa guilty of any of the possession of a large capacity magazine, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question: did Mr. Alissa possess the large capacity magazine during commission of a specified crime? Answer yes or no. Mr. Alissa possessed the large capacity magazine during the commission of a specified crime only if, number one, the defendant possessed a large capacity magazine during the commission of murder in the first degree, as defined in your instructions. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. A crime is committed when a defendant has committed a voluntary act prohibited by law together with a culpable mental state. Quote, voluntary act, end quote, means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that Mr. Alissa had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. The term, quote, after deliberation, end quote, means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts, quote, intentionally, end quote, or, quote, with intent, end quote, when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts, quote, knowingly, end quote, with respect to conduct or to a circumstance described by a statute defining an offense, where he is aware that his conduct, if of such nature or that such a circumstance exists. A person acts, quote, knowingly, end quote, with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. In this case, certain words and phrases have particular meanings. Accordingly, you are to use the following definitions where these words and phrases appear in instructions that define crimes, defenses, special rules, and verdict questions. Quote, deadly weapon, end quote, means a firearm, whether loaded or unloaded. Quote, large capacity magazine, end quote, means a fixed or detachable magazine, box, drum, feed strip, or similar device capable of accepting or that is designed to be readily converted to accept more than 15 rounds of ammunition. A fixed tubular shotgun magazine that holds more than 28 inches of shotgun shells, including any extension device that is attached to the magazine and holds additional shotgun shells, or a non-tubular detachable magazine, box, drum, feed strip, or similar device that is capable of accepting more than 8 shotgun shells when combined with a fixed magazine. Quote, large capacity magazine, end quote, does not mean a feeding device that has been permanently altered so that it cannot accommodate more than 15 rounds of ammunition, an attached tubular device designed to accept and capable of operating only with 22 caliber rimfire ammunition, or a tubular magazine that is contained in a lever action firearm. Quote, peace officer, end quote, means a person who is included within the provisions set forth below and who meets all standards imposed by law, as described in the provisions set forth below, is a peace officer. A peace officer, including a chief of police employed by a municipality, is a peace officer whose authority shall include the enforcement of all laws of the state of Colorado. A peace officer is, quote, engaged in the performance of his or her duties, end quote, if he or she is engaged or acting in or is present for the purpose of engaging or acting in the performance of any duty, service, or function imposed, authorized, required, or permitted by law to be formed by a peace officer, whether or not the peace officer is within the territorial limits of his or her jurisdiction, if the peace officer is in uniform or the person committing the assault upon the offense against the otherwise acting toward the peace officer knows or reasonably should have known that the victim is a peace officer. Quote, person, end quote, refers to a human being who has been born and was alive at the time of the homicidal act. Quote, possession, end quote, constitutes a, quote, voluntary, end quote, voluntary act, end quote, if the actor was aware of his physical possession or control thereof for a sufficient period to have been able to have terminated it. Quote, serious bodily injury, end quote, means bodily injury that either at the time of the actual injury or at a later time involves a substantial risk of death, a substantial risk of serious permanent disfigurement, a substantial risk of protracted loss or impairment of the function of any part or organ of the body, or breaks, fractures, a penetrating knife, penetrating gunshot wound, or burns of the second or third degree. Quote, universal malice, end quote, means conduct evidencing a willingness to take human life indiscriminately. The evidence in this case has raised the defense of insanity as a defense to the crimes of murder in the first degree, criminal attempt to commit murder in the first degree assault, and unlawful possession of a large capacity magazine. Mr. Alissa was insane at the time of the commission of the acts if, number one, he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or number two, he suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an essential element of a crime charged. But care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. In addition, quote, disease or defective mind, end quote, does not refer to an abnormality manifested only by repeated criminal and otherwise antisocial conduct. Similarly, quote, mental disease or defect, end quote, means only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality, and they're not attributable to the voluntary ingestion of alcohol or any other psychoactive substance. Quote, mental disease or defect, end quote, does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The prosecution has the burden to prove beyond a reasonable doubt that the defendant was not insane at the time of the commission of the acts. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions. After considering all of the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove that the defendant was sane at the time of the commission of the acts, which is an essential element of murder in the first degree, criminal attempt to commit murder in the first degree assault, and unlawful possession of a large capacity magazine. In that event, you must find the defendant not guilty and have the foreperson sign the designated section of Part A of the verdict forms to indicate your verdicts. After considering all the evidence, if you decide the prosecution has met this burden of proof, and the prosecution has proved that the defendant was not insane at the time of the commission of the acts, in that event, your verdicts concerning the charges of murder in the first degree, criminal attempt to commit murder in the first degree assault, and unlawful possession of a large capacity magazine must depend upon your determination whether prosecution has met its burden of proof with respect to the remaining elements of those offenses. Mr. Alissa need only be insane at the time of the commission of the crime to be found not guilty by reason of insanity. The relevant period of time for determining sanity or insanity is the time of the offense. Insanity could be temporary in nature or long-term. The question of sanity in a criminal case is an issue of fact to be determined by the trier of fact. When evidence of sanity is in dispute, the fact finder must resolve the conflict in the testimony and weigh all relevant evidence to determine whether the defendant was legally insane at the time of the act. This is an informational instruction and must have no persuasive bearing on the verdict you arrive at under the evidence. If Mr. Alissa is found not guilty by reason of insanity, it is the court's duty to commit Mr. Alissa to the Department of Human Services. The executive director of the Department of Human Services shall designate the state facility at which the defendant shall be held for care and psychiatric treatment, and may transfer the defendant from one facility to another if, in the opinion of the director, it is desirable to do so in the interest of the proper care, treatment, and custody of Mr. Alissa or the protection of the public. Mr. Alissa will not be released from commitment unless the court determines, after holding a hearing on release, that Mr. Alissa has no abnormal mental condition which would be likely to cause him to be dangerous to himself or to others or to the community in the reasonably foreseeable future. A release hearing may be ordered by the court on its own motion or upon motion of the prosecuting attorney or Mr. Alissa. The court need not hold a hearing unless the medical documentation is favorable to Mr. Alissa or unless Mr. Alissa demonstrates that there is favorable medical evidence to support his release. At the hearing, Mr. Alissa would have the burden to prove by a preponderance of the evidence that he has no abnormal mental condition which would likely cause him to be dangerous to either himself or to others or to the community in the reasonably foreseeable future. Mr. Alissa's commitment to the Department of Human Services upon a finding of not guilty by reason of insanity is indefinite unless the conditions described above are met. If Mr. Alissa is found not guilty by reason of insanity, he will never again be tried on the merits of the criminal charges filed here against him. It is Mr. Alissa's theory of the defense that he was insane at the time of the commission of the acts. Mr. Alissa asserts that he suffers from a chronic and serious mental illness with psychotic features which falls within the schizophrenia spectrum of disorders. Mr. Alissa further asserts that in the fall of 2020 into the winter of 2021, his mental illness worsened. Mr. Alissa acknowledges that he engaged in planning and preparation, but asserts that he did so as a result of his delusional beliefs and psychotic thought processes, and that his purpose for engaging in planning and preparation was to pursue these psychotic delusions. Mr. Alissa maintains that his delusional belief system was born of his mental illness, obscured his ability to make moral distinctions, and rendered him incapable of understanding that his actions were wrong from a societal perspective of morality. Mr. Alissa further asserts that his delusional beliefs interfered with his ability to act with reflection and judgment concerning the charged offenses. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time, except when all jurors are in the jury room. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. I will read instruction number 39 after closing arguments are completed. We'll start with the people's closing argument, please.
I have the screen.
Yeah, screened up. Do you want the microphone or?
I'm hoping, Judge, that
Yeah, move that one too, please.
you pressed it.
Okay.
This is fun. This is so fun. Statements Mr. Alissa made during the mass shooting, the pharmacist Sarah Chin told you about. You're sick. You're sick. Doesn't mean insane. Mental illness does not mean insane. Schizophrenia does not mean insane. Even severe schizophrenia does not mean insane. We talked about it in jury selection 3 weeks ago when I stood up here, and I talked about the two things that were necessary for somebody to be considered insane under the law. I told you during jury selection, Mr. Doherty told you during opening statement, and you heard from every doctor that testified in this case. Mr. Alissa is mentally ill. Mr. Alissa has schizophrenia. That has been consistent throughout this trial. Now, for the first time, the judge in instruction 32 told you the same two things I told you during jury selection 3 weeks ago. Mental disease or defect alone is not enough for you to find Mr. Alissa insane. You have to find one of two other things. You have to find that that mental disease or defect made him incapable of distinguishing right from wrong. You have to, under the other option, find that he was incapable of forming the culpable mental state, the intent to commit the crimes that he's been charged with. There's no evidence in this case, ladies and gentlemen, to support that either of those things exist. During opening statement, Mr. Doherty put up this slide. He encouraged you as jurors in this case to make your own little chart and to take notes and to keep track of the evidence that was presented throughout the course of the trial, showing that the defendant was capable of forming the intent, and the evidence showing that he was able to distinguish right from wrong. Everybody in this courtroom knows that the biggest question that you as jurors in this case are going to answer is that question. Was he capable of distinguishing right from wrong? If you listen to Mr. Dunn's opening statement, in all probability, you're going to be able to cross out one whole side of your chart if you made a chart. Mr. Dunn stood up here in opening and for the first time said, Mr. Alissa had the intent to kill when he went to King Soopers. That narrows the decision for you as jurors in this case even further. In all likelihood, the only question at the end of the day that's really going to be a dispute, was he able to distinguish right from wrong? If you didn't make your own chart, you can do it during deliberations. You can do it collectively. Some of you took copious notes. Some of you took notes that probably would rival the wonderful court report. Rely on each other. When you go back there to deliberate, you have any question, make a list. Make a list of all of the evidence in this case that showed Mr. Alissa's able to distinguish right from wrong, and make a list of all of the things. Any evidence that you've heard in this case, it would indicate he didn't have that ability. He didn't have the ability to distinguish right from wrong. Make two lists. It'll make answering that question much easier if you rely on the evidence that you heard here in this courtroom. When you consider sanity, when you're looking at sanity, and you think about those statements that I started with, this is fun, this is so fun, the statements from Sarah Chen, the pharmacist, think about it in the context of what Mr. Alissa said, not just to doctors Torres and Gray during the sanity evaluation interviews, but also to Dr. Janowski. What was he experiencing emotionally during the shooting? His response to the doctors across the board, adrenaline rush. Think about this is fun. This is so fun in the context of an emotional state that he describes as an adrenaline rush. That, ladies and gentlemen, is not insanity. Harold talked about it during jury selection. We've all had discussions throughout the course of the trial. The burden in every criminal case is on the prosecution. Mr. Doherty and I, as the prosecutors in this case, representing the people of the state of Colorado, have the burden of proof. You may be saying to yourself, why did they present days and days of testimony? Why did we get as much evidence as we got? Why are we not just stopping with Mr. Kupner's closing argument after he talks about sanity? This instruction number 3 in your packet tells you the burden of proof is on the prosecution, whether the defense contests it or not, whether they cross-examine, whether they fight about an element, doesn't change our burden of proof. Our burden of proof is to prove all of the elements. For every crime that's been charged, we have to prove all of the elements beyond a reasonable doubt. And so I want to walk through some of the elemental instructions the judge just talked to you about. The judge just read them to you and you have them in your juror notebooks. The relief for some of you during jury selection was visible when I told you that you'd be given a checklist. During jury selection, people were struggling, like, I don't know the law. The judge will tell you the law at some point, is what we kept telling you. You'll get instructed. Now you have the law. Those elemental instructions that she just read for each of the crimes that have been alleged against Mr. Alissa are those checklists that I told you you would receive. They're numbered. It's the list of things Mr. Doherty and I have to prove beyond a reasonable doubt in order for you as jurors to return a guilty verdict in this case. The evidence in this case, straightforward. What happened on March 22nd of 2021 is not a mystery. It was on video. Right now, I can press play. I could play that 8-minute compilation video that you saw last Friday, the 8 minutes of horror, the 8 minutes showing in detail how this defendant executed 10 people, including a police officer, at the Table Mesa King Supers. I don't have to hit play. I don't have to hit play because unfortunately, none of you will ever forget what he did. None of you are ever going to forget what you saw on the screens in this courtroom during this trial. I don't have to play it again for you to remember it. I don't have to play it again for you to return a guilty verdict in this case. It's in evidence. You have the CDs. If I'm wrong and you need to see it again, you'll have access to it. You can play it during deliberation. But I'm not going to press play because I don't think I need to. I don't think you will ever forget what you saw last Friday. First 9 counts. First 9 counts, murder in the first degree after deliberation. Instruction 14 tells you the first 9 victims. The 9 murder victims in this case, they were not law enforcement. The 9 civilians killed that day in King Supers. Go back. The first 2 elements on your checklist, 1 and 2 of every single crime, is that the defendant in the state of Colorado on or about the date. It's the last I'm going to say about that. It's all on video. He surrendered and was taken into custody on scene. After deliberation, murder. Murder in the first degree for those first 9 victims. Judge read you requires after deliberation and with the intent to cause the death. What do those words mean? She also gave you the definitions. Definitions of after deliberation is that it's something that is an act that involves the exercise of reflection and judgment. You think about it. It's not something you do just in a hasty fashion, in a spontaneous, quick manner. It's something that requires, for after deliberation, reflection and judgment. Intentionally or with intent is exactly what it sounds like. The conscious objective is to cause the result. In this case, did he mean to kill people? Was it his intent to kill people? Again, based on what you saw in that video last Friday, there's no question as to what his intent was. There's no question to whether or not the actions in taking these lives was something that happened after deliberation. But I want to walk through some of the things. After deliberation, certainly deliberation in early January when he started searching, page after page after page, Stephanie Sears testified, she told you she typed 9,000 items on his phone that she thought were relevant and pertinent to the investigation. Things like tactical helmets, tactical vests, firearms, optics, all kinds of searches, all of the information on his phone. Ladies and gentlemen, over that 3-month period leading up to this event, it's clear he was deliberating. But just the looking on the phone and just the thumbnail sketch, the thumbnails that we've put into evidence of the things that he was looking at aren't deliberation. What about when he started ordering the supplies to commit the mass shooting? January 3rd, he orders the first AR, the rifle. He orders an AR, a Ruger AR-556 rifle on January 3rd. Have all of the ATF transfer documents showing he's the one that purchased it. You heard all about how the process works. He ordered it from Grab a Gun online. It was shipped to a local federal firearms licensed dealer where he obtained possession after the background check. January 3rd, he started to amass the arsenal to carry out the attack. Deliberation when he, 6 days later on January 9th, bought the SAR K245 handgun. Along the same time frame, he's buying ammunition, 3 Hex-Mag AR magazines, and he continues to assemble the supplies necessary for the attack. Reflection and judgment, deliberation, all of this you can take into consideration when you're answering that question. More ammunition, more magazines for the AR. After deliberation, what was his intent? Look at his search on January 20th of 2021. A little more than 2 months before the attack. He's searching, what is the most deadly type of round or bullet? I think Dr. Lamoureux put it pretty well when he said in fancy words something along the lines of, his planning and preparation were designed to maximize and increase lethality. He wanted to kill as many people as he possibly could. That's what the evidence in this case shows. This is deliberation. When you start searching and investigating, reading the articles that came up on his phone, Stephanie Sears told you about. What is the most deadly ammunition? He's not deliberating then. Look at, after doing that search, reading about the most deadly ammunition. Look what happens on February 1st. Quantity 4, purchase 4 boxes. 5.56 NATO, 62 grain, green tip. Heard from the firearms toolmark expert from the FBI, who did all the trajectory work. Amy Quillia, she told you about those green tip rounds. Those green tip rounds are a steel penetrating round. They're not a regular round. They're not your target ammo. They're a steel penetrating round. After searching for the most deadly rounds, doing some research and investigation, he ordered 4 boxes. A few days later. Deliberation, ladies and gentlemen. Moving forward, 6 days. 6 days before the attack on March 16th of 2021, he purchased an optic. An optic, exact same optic you all look through. This optic that when you turn it on, each of you had an opportunity to take a look and see exactly what this defendant was looking at. What he placed on the head in many instances, or on the body of each of the victims before he pulled the trigger. That round circle, that round reticle that he put on the victim before he squeezed the trigger. When he purchased this, deliberation, reflection, and judgment as to the murders he was going to commit. You also saw when this turned around, the color it flashes. Everybody saw the orange. Jennifer Jacobson told you in the parking lot, thought maybe it had an orange tip, and it wasn't real. You see why she saw orange when he turned with the weapon. It's from the optic. Purchasing the optic, same day, same transaction, same receipt. On March 16th of 2021, he not only bought the $79.99 optic, but he bought a second AR. He bought a second AR. An AR, again, Ruger AR 5.56. In all aspects, identical to the AR he had bought on January 3rd of 2021. So why buy a second weapon? Why did he buy the second AR? Ladies and gentlemen, the second AR is classified as a pistol. We heard from the ATF agent about the difference between a pistol and a rifle and all the technical components. The only difference in those two ARs, the second one he bought 6 days before the attack, is shorter. It's shorter and more maneuverable. It's something easier to handle when you're looking to move fast, and you're looking to inflict as much damage, as much lethality as you possibly can. Deliberation, showing of his intent when he mounted the optic on to the new AR that he bought, the shorter, more maneuverable AR, sometime during the 6 days from March 16th, and when he showed up at King Soopers on March 22nd, deliberation intent. What about when he went shooting? He went and practiced. Searches on his phone show that he searched for White Ranch Park and shooting. You considering the issue of sanity, whether he knew right from wrong, whether he was capable of forming the culpable mental state. Think about what he told the doctors. When you're considering the question of sanity, you can take into consideration that he said I didn't commit the attack in January, didn't commit the attack in February when pushed by Dr. Janofsky, because I was still practicing. Wasn't ready. By March, I had enough practice. You get to consider those statements on the question of whether he could distinguish right from wrong, and on the question of whether he was capable of forming the intent to commit these crimes. Somebody who's amassing the arsenal necessary for the attack, practicing to make sure that their weapon doesn't jam, and that they're going to be able to inflict as much damage as they possibly can after deliberation and with intent. We move the days as the event gets closer to the day of the shooting. I have an evidence. The search is on his phone. He starts to look for a target. Starts to look for a target in Boulder. Initial searches you'll see in the days out, March 6th through March 18th. Public places. Places where there are going to be a lot of people, and he's going to be able to kill as many people as he can because that's his intent. Bars, restaurants. As it gets closer, when you get to the second day of the searches, towards the end of that, on the 21st of March, the day before the attack, the nature of the searches changes. Not to bars and restaurants, to public stores, Target, Whole Foods Market, Safeway, Plato's Closet, Safeway, Petco are the final searches for a target. Very first grocery store that he comes to, coming down 93, he's not going to do it near his house in Arvada. The store, his family, his family members told you there's a King Soopers by their restaurant and there's a King Soopers by their house. And they shop at both of those regularly. He wasn't going to do it there. Came to Boulder. And he stopped. The first grocery store coming into town off of 93. There's no question that he had been researching it. There's no question based on his search history in his phone that he was with deliberation, after deliberation, with reflection and judgment, and had the intent to take lives as he drove down 93 and came into Boulder. Other things that you can consider when you're looking at that question of after deliberation with intent, when you're looking at the questions of sanity in this case, what did he do? In addition to all of the research he did on his phone, in addition to all the things he purchased on the internet from local gun stores, all of the gear he amassed, as it continues to move forward, think about what he was doing. I want to give you an idea. I want to give you an idea of what deliberation and intent looks like. He sought out and he found 30-round magazines. 30-round magazines that you have in counts 50 through 55 that are illegal under Colorado law. They're illegal because in this case, he was able to kill 5 people before he had to change the magazine. He killed 5 people before that first magazine change in the store. Deliberation, as he loaded the magazines in this case. Unfortunately, he wasn't loading orange tip inert dummy rounds like I am here today. He was loading green tip, steel penetrating rounds into those 30-round magazines. Time for judgment and reflection. As he loaded the magazines, we're not talking about one magazine. We're talking about a whole bunch of magazines, ladies and gentlemen. You get the picture. He was thinking about it. He knew what he was going to do as he was putting each of those bullets into each of those magazines. Then he started the selection process. The selection process for what was going to go in this bag? What was gonna go in his rifle bag? What gear was he gonna bring with him for his big day? One of the things he brought with him. Carry your vest. Gotta have a place to put all those spare magazines, all your extra ammunition. Told you about buying the shorter, smaller gun with the red dot optic, more suitable for close quarters combat, the one you all looked through. That's the gun he selected to bring with him, was the shorter, more maneuverable gun. Long rifle, long, cumbersome rifle, hard to maneuver, hard to handle. If you're trying to move fast and inflict damage, that stayed at home. SAR K245 handgun. Ammunition's bigger. It's also heavier. Takes more to carry. SAR stayed at home. Other things that stayed at home. Things from the search of the house. Long range sight, probably for the rifle. Wasn't going to shoot people at distance. He was going to do it up close and personal. Ammunition, lots of ammunition. One thing you're going to find, you go through this evidence, you look at all the ammunition that was left at the house. The one thing you're not going to find in any of the ammunition that was collected at the house, you won't find a single one of the green tip rounds. Not a single one. All the ammunition from the house, not a single green tip. Lots of other types. Ammunition. Oh, case from the optic we already talked about. 4 boxes, ammunition. That all stayed at home. Stuff he brought with him, stuff he picked. All 6 of the 30-round magazines were recovered either from inside the King Supers or from his car in the parking lot. The other thing he didn't leave at home was a 30-round high-capacity magazine. Every single one of them he picked. Again, rounds from on scene, they're the green tip. The steel penetrating rounds, that's what he brought with him. Magazine, brought the 9mm handgun with him as well. 3 of these magazines, 3 magazines for the 9mm. The 9mm itself, lighter, smaller than the K2 SAR 45, easier, lighter ammunition. Again, this is the stuff he brought with him. 30-round magazine. Full 9mm magazines from the carrier vest. More magazines, more 30-round magazines, more ammunition. When you're considering the question of whether he acted in taking these lives after deliberation and with intent, think about what he bought, think about what he researched, and think about what he decided to bring with him. All of that is evidence in this case. After deliberation, you heard the testimony that when he first got to Boulder, he came down 93, made a left on Table Mesa, he drove past the store. He drove around in the neighborhood. He stopped, he parked on the side of the road for a minute. Opportunity for reflection and judgment. Came around, circled back, and pulled into the parking lot. Pulled into the parking lot, in the parking space, that's been Evan's work van. Seen the video, video's in evidence. He sat in his car. almost 5 minutes. Again, opportunity for reflection and judgment. This wasn't a hasty act, ladies and gentlemen. This is something that had been planned and prepared for at least 3 months, based on the evidence that we presented in this trial. Time to deliberate. As he sat in the car. Time to deliberate as he got out of the car, walked around the back of his car and up to the side, driver's side window, Nevin's van, fired the first shot. I submit to you that there should be no question that at that point in time, when he pulled the trigger for the first time, and fired the first round through the driver's side window into Nevin's van, that was after deliberation and with intent. But it didn't end there. He kept pulling the trigger. Kept pulling the trigger because his intent was to make sure Nevin was dead. 5 times. Nevin was shot 5 times. But wasn't within the intent to kill when he squeezed the trigger the first time. It sure as hell was with intent by the 5th time. Then he was on the roll. The roll of terror across the parking lot from west to east. You heard about the rounds that went all the way across the parking lot into the yoga studio, through the double pane glass, fragmenting into the walls. The distance it traveled, you saw in the trajectile presentation from FBI, the rounds that went into the other vehicles in the parking lot. These steel tip rounds, these green tip steel penetrating rounds aren't designed to stop. They're designed to go through things. And they certainly go through a human body. 5 shots tell you Nevin was killed after deliberation and with intent. Five shots. 5 shots ended the life of Nevin Stanisic. Moved across the parking lot. As he moved across the parking lot, took the time once he spotted Kevin Mahoney, who had just had that interaction with Jennifer Jacobson in the parking lot. She's walking behind him and they have the awkward interaction as they're putting their groceries in their car and closing their trunks. He goes to return his cart. After killing Nevin, draws the defendant's attention. Doesn't do anything. He wasn't doing anything but trying to put his cart back. Defendant starts to move, and he stops. Part of the reason you know that it was his intent and it was after deliberation, he takes the time to stop and brace on the white Prius. Detective Cantu told you about like stable shooting position. You're leaning, you're trying to become stable. Like you don't want to be running, you don't want to be, wobbling around. Takes a stable shooting position. He looks through an optic identical to the one each of you looked through. He places that red circle on Kevin Mahoney, and he starts to pull the trigger. Kevin ducks and he dodges. He tries to do his best to get away. He wants to live. But it was tenacious, and he was relentless. He shot, and he shot, and he shot. Probably a number of those rounds that went into the yoga studio and the vehicles in the parking lot, or when he was shooting at Kevin. The one thing he was going to make certain of, he was going to make sure Kevin died. His intent was to take Kevin's life. Ultimately, he pursues Kevin, pursues him across the parking lot when Kevin tries to run back towards the store, executes him in the main entryway. Kevin Mahoney. By the same smile that he gave to Jennifer Jacobson. Kevin Mahoney died from 4 gunshots. 4 gunshot wounds. With intent? No question what the intent is. When you shoot, when you shoot, when you shoot, till they're dead. Fortunately for Treylana was in the parking lot in her car. She hears the shots, she sees the shots, whatever alerted her. And she tried to get to safety. She pulled her vehicle into the front, kind of up by the ramp. She jumped out. And she started to try and run up the ramp to the safety of the store. She tried to escape. Jennifer Jacobson told you he shot her the first time and she went down. She wasn't dead. She went down and she was on the ramp and she was grabbing the rail and she was trying to pull herself up like you guys saw in the video last Friday. Any question as to his intent? When he moves across the parking lot, he moves up the ramp. I think Jennifer Jacobson described it as shot her point blank. Listen to the testimony in this case, you know, he may have tried to shoot her point blank twice. Dr. Langenfelter told you there was stippling, gunpowder embedded under her skin in her face, on the left side of her face. But it wasn't something that would correspond to any of the gunshot wound locations that he was seeing at the time of autopsy. Based on the evidence, I think he fired 2 rounds point blank. One of them finishing, killing Treylana. Treylana died on that ramp with the defendant standing over her. Again, 2 gunshot wounds, 1 point blank to end her life. No question, after deliberation and with intent. At that point, he moved up the ramp, moved into the vestibule, and he started to move into the store. So this graphic shows you the location of folks as he entered the vestibule before he actually stepped into the store. Ricky Olds, Denny Stong had come towards the entrance. You heard about the conversation that Denny had, that he thought maybe they were working on the roof and it was a nail gun. Him and Ricky moved towards the east entrance. Angela Peacock behind him. Aiden Steele, Casey Taylor, up at register 17. Lynn Murray being helped by Kay Mala. Kimberly Breckes checking out folks on register 10. Julie Keaton, all in the backdrop as he entered the store and he started to fire. There's a picture representing where they were right before he made entry. Denny standing on the left with his cup of coffee. Yellow top, you see Angela Peacock, who had just come in and had worked in the gas center. And Ricky Olds standing kind of a little before them, a little in front of them, closer to the east entrance in this photo, as he moves up the ramp and he starts to enter the store. As soon as he walks through the door, he shoots and kills Ricky. You heard the evidence in this case, ladies and gentlemen. Ricky is the only victim that had a single gunshot. Only one. When I talk about intent, I've stressed the intent to kill based on the number of shots. Because Ricky only had 1 shot, doesn't mean that he didn't intend to kill her. That optic that you all look through, he took that circle, and he took that red circle and he put it on Ricky's face. He may have only shot her once, but you know everything you need to know about his intent when he did so by the location. He shot her in the face because he intended to kill her after deliberation and with intent. The time he shot Ricky, you see people still in the background. This is from the graphic animation that Mark Subin from the FBI put together, that everything is synced up with the clocks, with the animation at 2:30:37:02. Approximately the exact time Ricky died. When he shot Ricky, you see who was in the line of fire. You see who was in danger behind her. Here's at the time, you actually see the muzzle flash in this picture. This is the muzzle flash of the shot. that killed Ricky Olds. The muzzle flash shows Ricky going to the ground as he shoots her in the face. You see Angela Peacock in her fluorescent top, trying to run to get away, starting to slip, starting to fall, that she came in and described to you. Maybe a slip and fall that saved her life. One shot after deliberation and with intent, ended a young and promising life of Ricky Olds. Next counts, I've started to talk about a little bit the folks who were in the backdrop, the people who were in the line of fire, the people who were endangered by the defendant's conduct. When he's firing rounds and there's other people that could have been hit, that's been charged as extreme indifference. These counts listed on the screen, and these victims are the victims that we identified as the civilians in the store that were endangered when the shots were ringing out in the front. Extreme indifference. Judge read you the instruction. Again, under circumstances evidencing an attitude of universal malice, manifesting extreme indifference to the value of human life generally. He didn't care if people died. His intention was to kill people, and if there were people behind the person he was targeting and shooting at that died, didn't care. Substantial step. Because these are attempts, because these people didn't die, it's not an extreme indifference first degree murder. It's an attempt. Attempt means that he took a substantial step. Substantial step is firing in the direction of another human being and not caring if they live or die. Extreme indifference. Attempted extreme indifference is a number of these counts in the front of the store. Universal malice. Instruction 31. This will actually be on the second page of instruction 31 all by itself, saying universal malice. It's one of the phrases used in extreme indifference, first degree murder. Means conduct evidencing a willingness to take a human life indiscriminately. Didn't care who killed. Didn't care that there were people in the backdrop, people in his line of fire, downrange, however you want to say it. He didn't care about any of those people in the front of the store. If you hit them, you hit them. If they died, they died. Ladies and gentlemen, that's extreme indifference. That's attempt at extreme indifference when he's raining rounds through the front of the store. Even if he's focused on a specific target, he doesn't care about the people endangered behind. Attempted extreme indifference, first degree murder. That round, fortunate for Casey Taylor, fortunate for Hayden Steele, fortunate for Angela Peacock, was stopped by the register. After ripping through Ricky Olds, that round went into the corner. Went into the corner of the register, went through the metal and all the internal workings in that register, the self-checkout. It didn't make it through. You see Ricky starting to go down in the bottom left of this photo. And you see Angela Peacock slipping and falling. When you look at the trajectory of that round, you also see Hayden Steele, Casey Taylor in the background, starting to scramble, starting to run. When he shoots Ricky, they're all in the line of fire, ladies and gentlemen. Paul Johnson at register 11. He hears the shots. He turns. He looks back. Here's Casey and Hayden checking out. Hayden told you they were buying a couple pizzas and a couple teas. They ran over across the street from where they live to get lunch. Here are Casey and Hayden at 2:30, 24:10 frames in. Just seconds before the shooting started. Standing trying to check out. Trajectory of these rounds. You see first up at the top, T24. Trajectory 24 that Amy Quillia told you about is the one that ripped through Ricky Olds and embedded in the register behind her. Trajectory that when you look at register 17, where Casey and Hayden were standing, when you look at where Angela Peacock was standing, where she slipped and fell right behind self-check 22, there's no question. Extreme indifference with respect to their lives. When you walked in and you shot Ricky with them standing behind her. T23, Don't know when this shot was fired, but it's likely during the same time frame because the trajectory is just slightly over. But again, endangering folks further to the west in the store. Micah Wong, who had started to move down the aisle, started to move into an aisle trying to escape once the shots rang out. Others were endangered. Kamala. But it wasn't Angela Peacock's fluorescent top that drew his attention. She was falling down behind the self-check where he had just shot and killed Ricky. It was the movement of Denny Song. Denny tried to run. Denny turned and he started to run through the front of the store. Defendant turned. And again, he's not firing in a crazy fashion. He's not spraying bullets through the front of the store. He's acting after deliberation and with intent. When he raises the gun to his shoulder, he looks through the optic, puts that red circle on Denny, and you see the muzzle flash as he squeezes the trigger. You watch the video close, he hits Denny. And he's got hole and blood on his back as he goes down to the floor, scrambling, desperately trying to live, just wanting to live, wanting to escape, wanting to get away. After getting shot, he goes down and he scrambles, tries to crawl away between the registers and the checkout lanes. You all saw the video. There's no question of what the defendant's intent was at that point. So he walked up, stood over Denny, and he executed. Again, point blank. His intent was to kill Denny, and he was going to make sure it happened. He ended Denny's life. Denny's 20 years old. Denny was 20 years old, and he ended his life standing over him as he was fighting and trying to live, shooting him point blank. No question that that was after deliberation and with intent to commit murder, with the intent to cause Denny's death. During that same time frame, as he's shooting at Denny, Denny's running away and he's shooting. We know he gets at least one into Denny's back because of the mark on the video we see as Denny goes down. Here are the other people in the front of the store. I talked about aisle 6, Micah Wong, who had heard the shots and started to move. Micah Wong, that second trajectory that I showed you earlier, the one that is in the registers of the self-check next to where Ricky was killed, that trajectory, if you look at that trajectory, it's almost directly at Micah Wong. You look at the other individuals who are in the front of the store, Kamala, Kim Breckus, Asia Beresford, Patrick Cruz, all of them are in the line of fire as the bullets are flying from east to west across the checkouts. Mr. Cruz came in here with his walker and he sat there and he told you that he knew his legs weren't good enough. He knew he couldn't get away. He knew there was nothing he could do to escape when the shots rang out and the bullets were flying past his head. There's a bullet that passed between Mr. Cruz's head and Terry Liker's head. I'll show you the hole in the plexiglass. Mr. Cruz knew he couldn't run, so he laid on the ground and he played dead. He hoped the defendant would believe he had already been shot and that he was dead. It saved his life, ladies and gentlemen. It saved his life. Mr. Cruz was one of those individuals in the front of the store that was in the line of fire. He's one of those folks that had bullets whipping past him. Here's the bullet I'm talking about. Mr. Cruz, you'll see, was at register 9. There we go. Mr. Cruz is standing at register 9. And looking at this, look at where Mr. Cruz is on register 9. Terry Liker standing next to him. Look at register 7. Register 7 is where this trajectory rod, maybe, same trajectory rod, just from a different angle, going through the plexiglass. If I want to go back, if I can. There we go. Register 7 is the register just past register 9, where Mr. Cruz was standing. When this bullet whipped past his head, went through the plexiglass, and ended its flight in the back of the floor's refrigerator. James Graham. Mr. Graham came in and he told you about going over to lunch. He was going to grab some lunch. He's buying some ramen. He's checking out. He's scanning his ramen. You look at the timestamp. Would have been just a little before 2:30. Again, the overhead cameras are off by an hour. You heard about that. He hears the shots and he starts to run. You look at Mr. Graham's right boot. Put this in so you could see Mr. Graham's right boot and what his boot looks like. Because as Mr. Graham turns and runs, the rounds are flying past him. You just catch his left boot, the bottom right of this picture. You catch his boot at the bottom right of the picture. You also catch Jody Waters ducking and hiding, trying to run, trying to get away. As this round rips in to the sign that hangs over register 3. This is the bullet. Mr. Graham didn't know where the bullet came from, didn't know where it went, didn't know what exactly happened. Mr. Graham just indicated in his testimony he felt glass or something showering down on him as the bullets were coming by, and he felt something shower down on him. It's the plastic. It's the plastic from the register 3 sign. In that photo, you can also see other impacts. Like you see around, you see H100, the hole that went through the outside of the sign, but you see H95, the hole that goes through the back of the florist's refrigerator. You see impact I-96, you see impact I-97, another one below it. These are the bullets coming down the front of the store, ladies and gentlemen. These are the bullets whipping past all the people that were in those registers, whether they were customers or employees, when the defendant is firing from east to west from the front of the store. Here's the back of that sign, a close-up of the back of the sign showing the plastic that was blown out. Plastic that, if you look at the stamps, you look at the stamp of when Mr. Graham's foot is in the bottom right-hand corner and Jody Waters is ducking, it's 70 frames. It's not even a whole second. It's 30:37. Mark Subin told you that last number is the number of frames. It's 70 frames later that you see the debris on the ground, the plastic that James Graham describes showering down on him. It tells you how close those shots came. Attempt, extreme indifference, murder in the first degree for the people who live only by the grace of God. Again, we see all the folks who were in the front of the store. This is closer in time. Again, that photo of Mr. Graham was 2:30:37. 2:30:37, it shows him in the area of that register 3 where the sign blows up. Jody Waters is in that picture I showed of ducking and moving back towards the interior of the store. Saw in that location, Lynn Murray, Kamala, hunkered down, hiding by the register. The defendant continued to move. He continued to move looking for targets, continued to move looking for people. And unfortunately for Lynn Murray, she tried to get away. She tried to run. First approach was to hide. As the shots continued to ring out and he continued to move from east to west in the store, she knew that hiding might not work. She had to try and get away. That's what she did. She scrambles. She runs. She's doing her best to get away. In this video, you see him pursue her. Again, the movement caught his eye. Once the movement caught his eye, his intent for her to die was clear. Tenacious. He pursues her. Pursues her throughout the check stands as she continues to try and flee. As he pursues Lynn Murray, who's trying to get away, comes across Terry. Terry Likert in the video you saw tried to pull herself up. She'd either fallen or was hiding on the ground, hunkered down. She was using that banana rack or display rack on the end of the aisle where you see her orange circle in this graphic. She's trying to pull herself up as a defendant comes around the corner pursuing Lynn Murray. Terry Likert comes a target too. This video, as he moves around the corner and both of them come into play, quickly, he shoots and kills Terry and Lynn. Lynn Murray tried to get away. She tried to run. Her movement caught his attention. Just like the other victims. She was murdered after deliberation and with intent. Lynn Murray, 4 gunshot wounds, took her life. Terry Likert, her smile and joy that she brought to this store, you heard from some of the customers and the other employees. Her life ended with 2 gunshot wounds as it came around that corner, and she struggled to try and pull herself up on that impact. Next counts I want to talk about, again, little change. These are counts of attempted murder in the first degree after deliberation and with intent. These are people that he targeted, he intended to kill, he shot at, identifying them as a target, trying to take their life, and they lived. Sarah Moonshatter and Nick Edwards. Both of them testified. Christopher Tatum, heard from him as well. Same exact elements. Everything like the first 9 counts I talked about, all the same elements. The only difference is that you have that substantial step. It's the same after deliberation with intent, just they didn't die. Raised the firearm, pointed the optic, tried to zero in on him with the optic, and pulled the trigger, intending to shoot him. That, ladies and gentlemen, is a substantial step in commission of murder in the first degree. This photo, People's Exhibit 19. You see Jody Waters in her position of hiding by register 4. You see Sarah Moonshadow in the bottom right of the screen, starting to flee as he comes around into the self-check area. And you see her son, Nick Edwards, starting to crawl, trying to move, trying to head in the direction of the west exit as the defendant's moving fast, coming around the corner. Continues to move. Here's the next shot of Sarah just making it out of frame. But it raises the rifle. It raises what is a pistol, but he shoulders it like a rifle, and he aims at them. The movement has drawn his attention, and he tries to shoot him. He tries to shoot at Sarah and Nick, but fortunately for them, the bullet's captured by a self-check register, by the receipt box where the receipt prints out of. Here's the trajectory. This is the trajectory. Upper left corner of this photo, or this diagram, is the west entrance or exit. It's the west doors that Nick and Sarah were trying to run to. As they ran from register 4, they ran around, and they're trying to make it to register or out the west doors. Look at the trajectory that comes across when he fired at them. The only reason that that is an attempt is because the register caught the bullet instead of one of them. That is attempt to commit murder in the first degree after deliberation and with intent. You also on this see the trajectory of a couple of the other rounds. The round that I talked about earlier where I showed the plexiglass that zipped in between Terry Likert and Paul Cruz before he laid down on the ground. You see that on here. You see the one that flew past James Graham's head as he described hearing shooter yell, "Fuck you," as shooting up the front of the store. That trajectory is on this diagram as well. You see here, the west doors. Those west doors that I was talking about on the diagram behind where this round went. You see this round down here at the bottom. It's kind of on the lower area. There's also the trajectory rod up in the self-checkout number 3 side. But what I'm looking at is this receipt machine down on the bottom where the round is directly towards the west doors where Sarah and Nick were trying to escape and ultimately did escape. When Nick and Sarah escaped, he let them go. When he fired at them, he targeted them and he fired at them, but when they managed to make it to the west exit and get out of the store, he didn't pursue them out of the store. He turned and he started to move back into the store to look for more targets. But when he turned, he started back into the store, he found Jody Waters in her position of hiding. Jody had hunkered down and was hiding by self-check 4. He turned. After deliberation with intent, again, point blank, ended Jody Waters' life. Jody died of 4 gunshot wounds. No question, his intent was to cause her death. What I've just described to you, up to the death of Jody Waters, what I've described, Mr. Doherty told you in opening, took 68 seconds. 8 lives ended in 68 seconds. About preparation, planning, practice. 8 lives in 68 seconds doesn't happen. These lives were taken after deliberation and with intent. But it didn't end. About the same time frame, we have 1 count of extreme indifference first-degree assault. That count is for Ree Shakti that came in and testified that she fell. There's a still shot of when she went down. She told you she fell face forward onto her stomach and she couldn't move. The wind had been knocked out of her, but she couldn't move. She couldn't open her eyes. She could hear people running by on the sides, but she couldn't move to help herself. And she thought she was going to die. Fortunately for Ree, Christopher Tatum was coming back into the store. He was coming back into the store for the 2nd or 3rd time after helping people out of the store. He saw Ree fall, and he went over and he helped her up. He helped her up and he helped her out to save her life. You look at the timestamps, this is at 2:30:56. If we were to go back to the Sarah Moonshadow and the Sarah Moonshadow Nick Edwards photograph, that's just around the corner. Again, the deli is up on that west end at 2:30:58. Like, we're talking seconds difference between when this is occurring. This has all happened simultaneously. Ree's trying to run because the defendant is firing shots in the front of the store. Extreme indifference. He didn't care who died. And when Ree tried to run, she fell, she broke her back. Medical records are in evidence. If you have any question about it, she told you she broke her back. Detective Cantu told you she looked at the medical records, and the medical records say she has a broken back. That is the first-degree assault under an extreme indifference theory. Defendant continues hunting, continues to look through the store for targets. Getting Ree out of the store. Humble, heroic Christopher Tatum goes back into the store again. And when he comes back into the store for that final time, he sees his buddy Andy kind of froze, paralyzed, somewhere back in the meat seafood section. And at this point in time, you see Christopher Tatum crouched down in the area of the deli, hiding behind a display rack. And you see the defendant continuing to walk up and down the aisles with his gun, looking for targets. Defendant moves to the back of the store. Christopher Tatum moves to the back of the store as well. When they get to the back of the store, you see on the diagram, very top left, you see the fuchsia representing the defendant, who's in the back thoroughfare, whatever you want to call the back main aisle of the store. And he sees the yellow dot that represents Christopher Tatum trying to escape, trying to run out through the meat and seafood after yelling at his friend Andy and getting Andy moving. Top right video. See what we've seen time and time again. See the defendant shoulder the weapon, look through an optic identical to the optic he passed around and looked at, trying to target Christopher Tatum with that red circle. And he pulled the trigger. Pulled the trigger trying to shoot Christopher Tatum, and that's why this is charged as attempted first-degree murder after deliberation and with intent. He was purposely shooting at Christopher Tatum as he was running out the back of the store. We know he was shooting at Christopher Tatum as he tried to run out the back of the store. We have the trajectories in the back of the store. There's actually 3 bullet holes by the sink that, if you recall the testimony of the FBI trajectory analyst, Amy Kulia, those trajectories correspond to when he's trying to kill Christopher Tatum. Again, 2 of them have the trajectory rods. One of them, there's no trajectory, but there's a 3rd hole. He fired at least 3 shots. After deliberation, with intent, pulling the trigger 3 times. Substantial step, ladies and gentlemen. Continues to move through the store. Continues to look for more people to kill. This is when he comes past for 2nd or 3rd time aisle 10. See in some video that I'll show you, you'll see in some materials that I'll present in a little bit, that he moves up and down the front of the store. You saw aisle 10. Saw that aisle 10 had that fruit snacks display rack. It was like a display box of fruit snacks in the aisle. It was turned. At some point it got bumped and it got moved because the trajectory is not right. We know where he was standing when he killed Suzanne Fountain. He was standing at the end of the aisle. He was shooting down the aisle. So at some point we know that fruit snacks box the fruit snacks display got moved a little bit. Well, what we know is that Charles DeFrance from the FBI, the evidence response team, said that you could hide behind that. Somebody could have concealed themselves if they were hiding behind the fruit snacks display and ducked down. Somebody passing the front of the store on that front aisle wouldn't see a person in aisle 10. Wouldn't see him. But the position of concealment was no more from the back of the store. Whether Suzanne Fountain tried to move from her position of hiding that was a position that protected her and kept her hidden from the front of the store, or whether just in coming down the back of the store and looking up aisle 10, he was able to see her where she was hiding. At this point, he finds her. He finds her, what we've seen time and time again. He's not randomly spraying bullets. He raises the weapon to his shoulder, looks through the optic, puts the circle on her, and he pulls the trigger again and again and again. Shooting rounds down aisle 10. Shooting rounds down aisle 10. Here's a close-up, showing the weapon shouldered, chick on the stock, looking down the sight, looking down the optic. No question, his intent was to kill Suzanne Fountain. Suzanne Fountain would die on aisle 10, while Dr. Allison Sheets laid in the aisle next to her, hidden in the chips, listening and knowing that the person who she just heard shot was passing away. 3 shots. Hit Miss Fountain. No question. It was after deliberation and with intent. Next count I'm going to talk about is is described to you as the checklist in instruction number 17. It's first-degree murder, after deliberation with intent of a peace officer. All the same elements we talked about, no difference. The only difference is the addition of an element that is number 7. The victim was a peace officer. In this case, that's not in dispute. The 10th victim that we're going to talk about is Officer Eric Talley. By this point, the 911 calls had been flooding in. You've heard some of those calls. Some of those calls are in evidence. And the police were responded. One of the first officers on scene was Officer Eric Talley. Officer Bianco, and Officer Jignian. 3 of them, when they arrived on scene, ran into the store. They ran into the store, and once they got through the vestibule, you'll see in the bottom video clip, the bottom video picture on the screen. You'll recall from the video, they moved cautiously. But as they moved into the store, you heard on the video something else. You heard their radios. You heard the chatter of their radios, making no question that the police had arrived. What did the defendant do? You surrender at that point? No. Moved into a position of concealment. Position that Dr. Lamoureux described as a flanking position for ambush. He moved out of sight, hidden off to the side where the officers couldn't see him. He waited. And waited as the officers slowly moved into the store. And the second that Officer Talley was slightly ahead of the other officers, stepped from behind the visual protection of the display rack and the wall from the customer service booth, the defendant from that position of ambush raised his weapon to his shoulder, looked through that optic, put that red circle on the side of Officer Eric Talley's head, and pulled the trigger. After deliberation, with intent, there was no question, ladies and gentlemen. He fired another round as Officer Talley went down after being struck and killed instantly by the shot to the head. There's another round that you heard about that was fired at the same time. First-degree murder, after deliberation and with intent of a police officer. Into the life of Officer Eric Talley. Next counts I want to talk about. Extreme indifference. Already talked about extreme indifference. It's basically not caring who dies. Taking actions that you're manifesting that indifference, extreme indifference, universal malice, all the things we've talked about, all the same elements. An attempt, all the same. With respect to these counts are pertaining to the law enforcement officers that made entry and were in danger based on him firing in their general direction. Extreme indifference. We don't have to prove that he was specifically targeting any of them. There'll be separate counts for that. But just that he engaged in conduct, putting them in a significant risk. I highlighted Officer Capobianco because you may look at this and you may say, oh, that must be a typo. There's count 29 and count 42 are both extreme indifference counts. The first count is based for his position on the first entry team. The entry team that included Officer Talley when he was killed and they made entry and he fired on that first team. Officer Capobianco went back in a second time as part of the second entry team, and that's why there's 2 counts of extreme indifference for him. There are also, you will see, counts charged for some of the officers for attempted murder on a police officer after deliberation and with intent. And I want to explain the difference and kind of where the lines are with respect to what we have charged in this case and how you will find that the defendant committed each of these offenses. Second entry team sets up starts to move up. In this picture, in this diagram, you can see all the small dots on the diagram as they start to move into the vestibule and into the store. More precisely, a little zoomed in, you can see the difference in the counts. Deputy Brunkow from the Sheriff's Department and Ranger Kilburn. Those two, you will not find attempted first-degree murder after deliberation with intent of a police officer. You will not find those counts because of their position. You look at the wall, they are both in a position when the officers are fired upon that he could not conceivably see those two officers. He could not see. Deputy Brunkow was to the left far enough that he was hidden behind the wall. And Ranger Kilburn was outside enough that there's no way that we could make an argument to say that he was intending to fire at those two officers. So you will not find an attempt charge after deliberation with intent for those two. Otherwise, when he moves to the back of the store and he sets up at the back of the store, down the aisle, and waits for that second entry team, and then opens fire on them, all the officers that were in his visual sight line, all the officers that he was pointing the firearm at and shooting at, we have charged that after deliberation with intent. We've also charged the extreme indifference, because he didn't care which of those officers he killed. He didn't care if he killed them all. Here are the officers already identified in the count. The one officer that I'll mention that is in this photo is Officer Stidel. Officer Stidel is the officer that when the defendant opened fire from the back of the store and the glass was breaking all around the officers and they were retreating, Officer Stidel didn't retreat. He went to a prone position laying in front of the customer service center and remained inside the store. Remained inside the store. Here again are the positions of Deputy Brunkow and Ranger Kilburn, showing why we did not charge the after deliberation counts. Officer Stidel from that prone position, as the defendant moved back and forth across the back of the store, he presented himself as a target. Fired. And he wounded the defendant. You heard about the gunshot wound to his leg. You heard that that ended the killing. That was the end of the defendant's reign of terror. He had been shot. I want to transition, after talking about all of what the defendant did in committing these crimes, back to where I started, and I want to talk about sanity. Talked about the fact that we've had it defined by the court now. It's defined in instruction 22. The one element I didn't talk about, every single one of those elemental instructions, most of them it's element 7, many of them it's element 8, but all of them have the element that we have to prove beyond a reasonable doubt the defendant is saying. That's part of our burden. It's part of one of those elements for each and every one of the crimes that I've described to you. I want to walk you through some of the things that will help you to know that we have proven beyond a reasonable doubt each and every one of those elements, including the same. Again, got over this and over this, you've heard it a bunch of times. Part I want to stress is instruction 34. Got to look at instruction 34 in conjunction with instruction 32, because what it tells you is you as the trier of fact, you as the jury in this case are the ones to answer the question of have we proven beyond a reasonable doubt the defendant was sane when he committed these crimes. That question of was he capable of distinguishing right from wrong? The question of was he capable of forming the culpable mental state? In order to do so, this instruction is important because it tells you that you can weigh all relevant evidence. There was some discussion during jury selection about do we get to consider the preparation and the planning, or because it's just at the time of the offense, like what do we get to consider? Instruction 34 gives you the insight. It tells you get to consider everything. You get to consider all of the evidence. You get to consider everything I put up there as deliberation, everything from a planning, preparation, practice, all of that you can take into consideration because that's all relevant evidence on the question of sanity in this case. Next thing I want to talk about on the sanity issue, talked an awful lot about the things the defendant did on March 22nd, 2021. Next thing I want to talk about are the things he didn't do. I believe I would encourage you to look at what was going on in his head, what decisions he was making while he was conducting the mass shooting. Two of those are Clint Ponsford and Paul Roeder. You heard about both of them during the trial. These are out of order. This is in the middle of the killing. I want to be clear. This is not after he was done and he had just decided he was done killing people and he was ready to stop. This is right in between. There are people killed before this, what I'm going to show you, and there are people killed after what I'm going to show you. So I want to emphasize that this is a conscious decision being made by this defendant at this time not to take these two lives, despite having every opportunity to do so. I think it gives you a lot of insight into his thought process and what was going on in his head while he was committing the mass shooting. First one, Clint Ponsford. You heard about Clint? He's a cart guy, a courtesy clerk that goes and gets the carts and helps bag and is working at King Soopers. And he's been out in the parking lot and he comes walking in after the shooting started. Clint's developmentally disabled. And Clint comes through the doors and you can tell from the video, he doesn't quite understand what's happening. He's confused and he sees Ricky in the lower right. You can see he comes in, he's looking and he sees Ricky dead on the floor. And he's just standing there and he's trying to figure out what's going on. What you see in the upper, this one's a little bit hard to see, but from the timestamps and from the diagram that shows it a little better, the defendant walks right past Clint Ponsford when he comes in that front door the first time. He walks right past him and you can see a direct line. There's no question that he could see Clint Ponsford standing inside the front door on the east end of the store. He doesn't even raise the gun. He doesn't even raise the gun. Ask yourself, what's different about Clint Ponsford? I'll tell you a couple things you do. Clint Ponsford showed no fear. Clint Ponsford didn't perceive what was taking place and understand what was going on. And showing no fear, he didn't hide. He didn't try and run. He just stood there. Think about that in conjunction with the Sarah Chen statements. This is fun. Somebody who presents no challenge. Clint Ponsford, who's just standing there, not understanding what's going on. He didn't raise the gun. He didn't kill. Is it because it wasn't fun? They weren't in fear, if they weren't running, if they weren't hiding? What we know is he had every opportunity to kill Clint and he didn't in the middle of his killing spree. Next one, you heard about Paul Roeder. Little old man who was shopping. He just kept shopping through the whole thing. Here you see, again, depending on the diagram, it's a little better. You can see it on the picture, but a little better on the diagram. Mr. Roeder is the green dot, kind of down aisle 17. Defendant standing at the head of aisle 17. When you're considering the question of sanity, think about his statements to Dr. Janofsky. Yeah, there was somebody I didn't kill. There was somebody that I actually pointed the rifle at, but I didn't shoot at. He describes the person as like in his 50s, older guy. Paul's way older than that. But we know who he's talking about. Again, this is the first time he is moving from west to east along the front of the store. He passes aisle 17. Mr. Roeder's just shopping. He's just continuing to shop, coming down aisle 17 at the defendant, towards the defendant. Defendant keeps moving. He stops, he raises the gun, and then he keeps moving. Mr. Roeder keeps moving in the direction of the defendant. He keeps moving down the aisle. There he is. He's just still shopping. And you see on the diagram, the defendant comes back by and has a second opportunity to take the life of Paul Roeder. And he elects not to do so. What's different about Mr. Roeder? Mr. Roeder's elderly. Mr. Roeder shows no fear because he doesn't understand what's happening. Mr. Roeder doesn't try and run, doesn't try and hide. He's just shocked. The defendant, despite more than one opportunity to take his life, lets Mr. Roeder live. Considering the question of insanity in this case, I urge you to think about what the defendant didn't do that day. Think about Clint Ponsford. Think about Paul Roeder and why they lived and what was different. And think about it in conjunction with those Sarah Chin statements. This is fun. This is so fun. It's a second chance on Clint too. Like, he keeps moving to the front of the store, and as he moves past Mr. Roeder, Clint comes back into the store a second time as the defendant is passing by the front of the store. You can see it in that clip, but clip was playing pretty fast. Defendant actually, in this video, when you freeze frame it, and you look at the defendant, as Clint comes through the front doors, as he walks past, he stops and he turns and he looks at Clint. And he makes no effort to take his life. Multiple efforts, Mr. Roeder and Clint, and he didn't do it. What happened after that? Also important for your consideration when you're looking at that question of sanity. He's been shot in the leg. He decides he's going to surrender. In order to surrender, not only does he put down his guns, strips off his tactical vest, shoes, socks, his jeans, his t-shirt, strips down to his underwear. What do you tell the doctors? Told Dr. Janofsky and asked, when you surrendered, you stripped off all your clothes. Why did you do that? I did that so I wouldn't get shot by the cops, was his response. I did that so I wouldn't get shot by the cops. That pretty clearly says that he understood the cops were there for him and that what he had done was wrong. He flat out said that to the doctors as well. He understood his behavior was illegal. He understood it wasn't good behavior to engage in. But the fact that he stripped down gives you insight into what was going on in his head. Changed his mind, decided he wanted to live. The plan was to die. The plan was to die so he didn't go to jail. That's the plan going in, ladies and gentlemen. What he described to the doctors, the plan going in was to die, not because anything in his life was bad, or he didn't describe anything other than he planned to die so he didn't go to jail. These are the 4 rounds that Charles DeFrance from the FBI evidence response team told you were recovered from the magazine of his weapon. He still had ammunition. It wasn't a matter of he was out of bullets. And this, again, tells us what he had the weapon loaded with. This, in addition to the rounds that were dug out, the rounds that were dug out of, I think it's Exhibit 68, is a piece of the green tip that they dug out of Register 9 or 10. The green tip rounds that were dug out of some of the victims at autopsy in this case. That's what he had loaded in his weapon. What else do we know about his after the fact conduct that will allow you to look at it, whether or not he could distinguish right from wrong, do what he was doing? Think about the video that you saw from Commander Bonafide. Video that showed him comply with every command. Comply with every command to a T. Turn around, put your hands up, back up, get down on your knees. Why are we putting him down out there? Let's get him up. Let's bring him back to us. All right, stand back up. Come back. Turn to the right. Step to the right. Step to the right. Come back. So the person is in a delusional state, person that is incapable of distinguishing right from wrong, that's able to comply with every single command immediately when directed by law enforcement what to do? Consider that when you're thinking about the question of sanity. Compliance with every single command, stripping down so the cops wouldn't shoot him. Think about the video from in the hospital. Search warrants executed. Raise your hand, turn your hand over, step to this side, turn. Every single command. That, ladies and gentlemen, is not somebody who is insane. Somebody who's sick. Somebody that a mass shooting is fun, they're sick. We agree he's mentally ill. He has schizophrenia, but he is not insane. Other statements he made during the interviews with the doctors for sanity. He'd hear the voices while he's working at the restaurant. What would you do? I just keep working and they go away. Talks about the voices. Mentioned a minute ago. Did you want to die at the time? Yes. What was going on? You had that desire. I did not want to go to jail. There is nothing in this case that speaks louder to being able, to being capable of distinguishing right from wrong than knowing he was going to go to jail if he didn't die in a shootout with the cops. He didn't say it one time. He told the doctors over and over and over again. I played a number of clips, and they're in evidence, from the interviews with Dr. Gray and Dr. Torres, where they kept coming back to, like, so tell us about why you wanted to die. I wanted to die so I wouldn't go to jail. My plan was to die so I wouldn't go to jail. In this case, there's nothing that answers that question louder and clearer in those statements. You feel justified in any way? No. Did you think it was a good behavior to engage in? No. When you decided to surrender, what do you think would happen? They would take me to jail? That's somebody who not only is capable of distinguishing right from wrong, but clearly has acted with deliberation, with intent, committing these crimes. Told you, well, Mr. Doherty told you during opening statement, every doctor who conducted a sanity evaluation in this case determined that the defendant was sane on March 27, 2021, when he committed these crimes. The evidence you don't have is testimony from any expert, any doctor, saying this defendant, based on our examination, our professional judgment and opinion, applying Colorado law, we believe that he was insane. You do not have that evidence. But I want to go one step further. At the very beginning, I put up this instruction 3, because it has the burden of proof in the second paragraph. I want to talk about the third paragraph. Beyond a reasonable doubt. That's the burden that we've talked about. We have in a criminal case, we have to prove each and every one of those elements on your checklist beyond a reasonable doubt. Reasonable doubt is a doubt which is not a vague, speculative, or imaginary doubt. What did Dr. Torres tell you? What did Dr. Gray tell you? When I asked them the questions, what evidence was there to support the defendant was unable or incapable of distinguishing right from wrong? They said there was no evidence. No evidence. And I followed up and I asked them the question. I said, in order to reach a finding, in order to get to an opinion that the defendant was insane at the time that he committed this crime, would you have to imagine evidence, imagine facts that don't exist? And they said, yeah, there is no evidence. I said, would you have to speculate about things that there's no evidence to support in order to reach a finding as an expert that he was insane? They indicated they would have to speculate to get there. I'm asking you not to speculate, not to come up with an imaginary reason for why the defendant could not distinguish right from wrong. There is no evidence to support that, and the doctors told you that. The doctors told you, Dr. Torres told you that after watching the interview performed by Dr. Janowski, her opinion was confirmed. it was solidified. It became certain. The defendant was sane at the time he committed these crimes. And there's no evidence to contradict that. You'll receive a jury verdict form. You'll receive one packet of jury verdict forms. You'll have 55 for each of the counts. Ladies and gentlemen, Mr. Doherty and I had the burden of proof in this case. And we have proven each and every element beyond a reasonable doubt, including proving that he was sane at the time he committed these crimes. For that reason, we ask you to go back and for all 55 of these verdict forms, sign Roman number 3, returning a fair and just verdict, returning a verdict and staying true to your oath. Return a verdict of guilty for all 55 counts in this case. Thank you, ladies and gentlemen.
All right, we're now going to recess. Let me tell you how the rest of the morning's going to go. I kind of told you the other day, I think it was Wednesday. So when you come back in about 15 minutes, Mr. Alissa's team will have their opportunity to do closing arguments. We'll take another break at that time. And at that time, I'm also going to have you all order lunch so that we have it ready for you when you are going to go back and deliberate. After that second closing argument and we take that break, the people have an opportunity to do their rebuttal argument. You do not have the jury verdict forms included in your notebooks. There's just going to be one of those. I'm going to give you what I have read you this morning. I will also have to read you all of those verdict forms. It will be equally as long as this morning was, which is why I anticipate it's going to be a long day. And I just want to give you that heads up. I want to remind you that until the trial is completed, you must not discuss this case with anyone by any means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, tell them to stop and let me know about it immediately. You must not read or listen to any news reports of the trial. You must not consult any outside reference materials, do any internet searches of this case, people involved in this case, or cases of this nature. Finally, remember, it is especially important that you do not form Ready for the jury?
Yes.
Okay. Let you go grab it. Rise for the jury, please. Thank you. Please be seated. Ms. Harold, whenever you're ready.
Thank you, Judge. Insanity is the only explanation for this tragedy. Mr. Dunn and I told you from the very beginning what happened on March 22nd of 2021 was a tragedy. There are no words that any of us can say that could properly express the extent of that tragedy. A tragedy my client caused. We have all felt the effects of this tragedy, and we're going to feel those effects long after we leave here. But what we know is that this tragedy was born out of disease, not choice. What we know is that Mr. Alissa committed these crimes because he was psychotic and delusional. On March 22nd of 2021, his mind was drowning in his illness, drowning in the voices. We know also that but for the psychosis he was suffering, this tragedy would have never happened. During jury selection, I told you this is a very serious matter. The impact that it has had and continues to have on the victims, their friends, family, and our community. The reality is that no verdict will alleviate the pain and suffering caused by Mr. Alissa. A verdict of not guilty by reason of insanity is holding Mr. Alissa accountable. You are saying that he killed 10 innocent people and endangered the lives of so many more. A verdict of not guilty by reason of insanity is not saying he's innocent. You're not saying he's getting away with it. What you are saying is that his mental illness, his schizophrenia, prevented him from knowing right from wrong. What you are doing is following the oath you all promised to take by saying the prosecution failed to meet their burden to prove beyond a reasonable doubt that Mr. Alissa was sane. And it doesn't matter whether you like it. It doesn't matter if it's hard. You promised us that you would do that. We chose you and believed in each and every one of you because you told us that if you saw a video where someone hunted down their victims, that does not mean they could never be insane. We chose you and believed you when you said someone could plan a mass shooting for months, if not years, and then commit that mass shooting. And that doesn't mean they could never be insane. You all knew this was going to be a very difficult task. I can only imagine how your emotions have gone awry throughout this process and will continue to. But you also promised that your verdict would not be influenced by emotion. And at the end of, you promised us that your verdict would not be influenced by emotion. And you've had a lot of emotion shoved at you, a lot of emotion pointed at you. But when you remove that emotion, it's clear that insanity is the only explanation for this trial. You have known all along how important the law is. We talked day one about the insanity test, what it is. You heard Judge Bakke tell you what it requires. It's not simple, it's complicated. But what the prosecution has tried to do is make this simple. What they've tried to do is come up with these little, well, if you're mentally ill, that doesn't mean you're insane. His schizophrenia doesn't matter that much. What we're talking about is wrongfulness or intent. That's not what the law tells you. Why we were going back to Mr. Alissa's schizophrenia is because it's what it's required for you to consider when you're considering whether or not he knew right from wrong. They're not separate. It's within the same, meaning that you need to think about his schizophrenia. Think about it before this happened and after, when you're thinking about what was going on March 22nd. It all plays within that. I also think this is important because it's not a checklist. Let go of this checklist. This is way too complicated. Every doctor told you how complicated it is. They're trying to simplify it into a checklist. The jury instructions tell you this isn't about a checklist. You're supposed to consider all of the instructions in their totality. We also did stand up here day one and tell you we are not contesting that Mr. Alissa had the intent. The first, second thing out of Mr. Dodd's mouth during opening statement. But what have they done? What did they spend day after day after day doing to you? Proving intent. Now, I don't disagree with Mr. Kuffner at all, that absolutely they have the burden and they have to prove intent. But did they have to show you that video over and over and over again? Did they have to bring victim after victim after victim? Did he just have to throw around all the items we know are Mr. Alissa's that we're not contesting they're Mr. Alissa's? Yeah. Trying to scare you. Trying to invoke your emotion. So you don't look at what is really going on here. What really happened that day. What was going on in the mind of my seriously mentally ill client when this tragedy happened. Don't be distracted. Stay focused on the real evidence. Jury instruction number 34. The question of sanity in a criminal case is an issue of fact to be determined by the trier of fact. That's you. You could tell all along throughout this trial, we were bringing it back to you. Question after question, we said, it's for the jury to decide. Dr. Gray told you that. Dr. Torres told you that. Dr. Westmoreland told you that. It's up to the jury. It's not up to the experts. You know what the prosecution tried to do? Well, Dr. Torres, you have way more education than anyone else. Dr. Torres, you're board certified. I absolutely know more than everybody else. That's not what the law says. That has nothing to do with it. Nothing. It's one data point for you to consider when you consider all of those data points in seeing that my client could not know right from wrong. And Dr. Gray absolutely told you this over and over. It's not up to me. I'm just giving you my opinion and thoughts. I'm not confident in my opinion. This is for the jury to consider because the jury gets to see everything. And they try to distract you with, oh, all the discovery everyone's reviewed. That's not the same as sitting in this trial and hearing from witnesses. Reading reports about what someone may have said is not the same as hearing how a family describes the deterioration of their son and brother. It's for you to decide. The burden of proof is on the prosecution. They're taking it on. My concern always is when I put on a case, you want to start comparing the evidence. Whose evidence is worth more than others? That's not how this works. It's all on them. And most importantly, they must disprove insanity beyond a reasonable doubt. This isn't just, well, I think that's what happened. Oh, my gut tells me something. No. We've spent a lot of time during the course of this trial talking about schizophrenia, what it is, how it develops, how it developed for Mr. Alissa, and where it's going to go from here. And this is so important because you can see exactly how he could never have known right from wrong when that happened. We brought in Mr. Alissa's family, his mother, his father, his sisters and brothers. And they were able to tell you so much about Mr. Alissa's schizophrenia. They were able to tell you that shortly after high school or right at the end of high school, this person they knew for so long, all of a sudden started to see changes. Changes that they weren't really sure why they were happening. What was going on with those changes? They started to just think that was his normal. But they told you about the progression. They told you about how when COVID hit, how much his symptoms changed, how much worse they got. And most importantly, they told you they could never have imagined this could have happened. Because even though he might have had some odd behaviors, even though he might have been talking, laughing to himself, not being able to work that well, they never, ever saw any violence. They never, ever saw any anger. They never could have imagined. They also told you that 2 days after, when the police came, how much of a tragedy it was for them. And not just because their son was a part of this. They felt the pain of the victims who died that day. And they tried to do everything they could to give the police anything and everything. Whatever you want, you can have it. They were able to tell you that from January to March, there was drastic changes in Mr. Alissa. You could see more of the paranoia, more of the delusions, the hallucinations. His schizophrenia is getting worse and worse and worse. And they told you that on that day, he was his normal. Talking to himself, laughing to himself, that was his normal. He drove one of his brothers to work. They thought nothing possibly could happen. He wasn't even supposed to have that day off. They also told you who their brother became, that they could have no idea. Pictures speak louder than words. The person on the left liked to wrestle, play jiu-jitsu, pick on his younger brother, liked to be with his family who was super close, travel. The person on the right was so delusional, so psychotic, hearing voices, killing voices over and over again, that he felt all he could do was try and make them stop. Jury instruction number 34. Again, going back to it's in your purview, it's up to you. And you need to weigh all of the relevant evidence. And Mr. Alissa's schizophrenia is a huge part of this in determining whether he knows right from wrong. What we learned from the family before the shooting, but just as importantly is what you heard after the shooting. March 29th, 2021. That's the first of multiple interviews Dr. Hatfield will have with Mr. Alissa. This is days after the shooting. And he tells you how sick Mr. Alissa was. Mr. Alissa was responding to internal stimuli. Mr. Alissa was isolating himself, had slow speech, didn't share anything. But days after, he was immediately able to diagnose him with schizophrenia after that first visit. September 2021. That's the first of the non-sanity evaluations with Dr. Torres. What does Dr. Torres tell you from back then? He was really, really sick. He exhibited significant symptoms of schizophrenia, in particular, negative symptoms, which Dr. Hatfield also talked at length about. These negative symptoms where you have an inability because of your disease to be able to share things like you and I could share things to each other. Because of your disease, you show no emotion. Because of your disease, you're hearing voices. November 2021, Dr. Westmoreland's non-sanity evaluation. Again, consistently seeing these same symptoms of schizophrenia. And this is important because this gets us back to March 22nd of 2021. And we're going to talk about it later about how Mr. Alissa was in the store, how he was immediately following this. This helps you understand just how sick he was. Then we get to December 2021, and he's transferred to the state hospital, and Dr. Pillai meets him for the first time. And Dr. Pillai becomes his treating physician and works with him for over almost 3 years. And he tells you about Mr. Alissa's schizophrenia, the prognosis of his schizophrenia, why his schizophrenia is so severe. And there is no typical schizophrenia, but Mr. Alissa's schizophrenia is exceptional, besides being so severe, because typically we expect to see those positive symptoms, right? The hallucinations, the paranoia, the things that now you know medication helps. With Mr. Alissa, that's not his prominent symptoms. His prominent symptoms are negative symptoms. Isolation, no emotion. Think about these things when you start thinking to that video. Isolation, no emotion. What's also important to know is that's when he starts staying at the state hospital, not at the jail anymore. He's at the state hospital. He's so sick that he has to be at the state hospital to make sure he can get his medication. He's not in the jail. And he stays there until trial. Throughout 2022, Dr. Torres continues to see Mr. Alissa, continuing to try to evaluate him, continues to see the same symptoms. There is no real improvement all through 2022. Dr. Pillai told you that the inability or the length of how long it can take to get someone to medication that's actually making a difference tells you how severe his schizophrenia is. They're really trying hard to disassociate all of this information you have around March 22nd, 2021, trying to say it doesn't matter. It has nothing to do with it. Well, schizophrenia doesn't come and go. If you have schizophrenia, you have schizophrenia. If you have a severe case of schizophrenia, you have a severe case of schizophrenia. If your prominent symptoms are negative symptoms, those are your prominent symptoms of your schizophrenia, particularly if you're seeing all the same things before and after. March of 2023, we hear that Dr. Arriaga Colorelli starts individual treatment with him. So Mr. Alissa is not progressing in a way that they want him to progress. So they make a special accommodation for him and put him into individual treatment. And I want you to remember this because this is important when we get to the sanity evaluation that happens almost a year later about what Mr. Alissa is able to tell us. He's in individual treatment at the state hospital. We also learned that they finally have found a medication that appears to start working in March of 2023. Clozapine, a medication known as last resort. We heard how potent it truly is. That's how severe Mr. Alissa's schizophrenia was. He couldn't use one medication or another. They had to go to the one of last resort to see any improvement. And they still see significant negative symptoms. It took until February 2024 for Mr. Alissa to be healthy enough to do the sanity evaluation. 3 years after the shooting, it took 3 years for him to be healthy enough to do the sanity evaluation. But you're supposed to believe, schizophrenia wasn't that bad. He could go to work. He could make his bed. He could sleep and eat. It wasn't that bad. There's no way that affected his ability to say right from wrong. He isn't in the jail. He's at the state hospital. He has to receive treatment, individualized treatment. Not just sitting in the jail. He has to be put on the most potent last resort medication to get him to a place where he can even do the sanity evaluation. Think about it. And then, as I said, we know he didn't come back until trial. And we know that Dr. Pillai, who was treating him as recently as July of this year, so 2 months ago, told you how sick Mr. Alissa is. That he suffers from a chronic, serious mental illness that will be with him forever. That he is deteriorating and likely will continue to deteriorate as time goes on. That the antipsychotic that he can finally take has such significant side effects, they have to monitor his blood on a regular basis. This all helps you understand what was going on March 22nd. Reasonable doubt. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence, or lack of evidence in this case. It's a doubt which is not vague or speculative or imaginary, but such a doubt that would cause reasonable people to hesitate in acts of importance to themselves. Now, prosecution wants you to say, well, it's speculative to think about what was going on in his mind, that it's speculative because Dr. Torres said that for her, in her evaluation, the way she has to do things, she can't consider outside information. She can only consider what Mr. Alissa tells her, right? That's for her evaluation. That's not for your evaluation. Your evaluation is not the same of what hers says. And that is really, really important. Because this information about what was going on with Mr. Alissa before, from his family, what's been going on after, that's not speculation. That's real facts that tell you how sick he was. And someone that sick did not know right from wrong. The other thing that's substantially different of why it doesn't matter what Dr. Torres told you about speculation is that you get to consider circumstantial evidence. And circumstantial evidence has the exact same meaning as direct evidence, right? When I think of direct evidence, I think DNA. That's how we connect someone to it, right? Circumstantial evidence, they give you this wonderful example. You wake up in the morning and there's snow on the ground. It's fair to say it's snow. Right? Well, if someone has followed the natural progression of schizophrenia over time, then it's a serious medical illness such as COVID. You heard Dr. Westmoreland tell you, what did she do during the pandemic? She worked directly with mentally ill people. And she saw how affected they were by COVID, particularly within their brain, and how it exacerbated their mental illness. And we know Mr. Alissa had COVID in November of 2020. And we know that he got significantly worse. The paranoia, the hallucinations, the isolation, it all got worse. It followed directly with what Dr. Westmoreland told you. And she hasn't seen or spoken with Mr. Alissa since November. This isn't speculation. This is evidence that goes directly to what he could not form, which was understanding right or wrong. So I want to walk you through why we know he's insane besides what I just told you. Things that they haven't discussed. Because it leads you right to the fact that he didn't know right from wrong. And it starts at the very top. If you're planning to do this mass shooting, that's all you're thinking about, and you absolutely know it's right from wrong. 2 hours before, I'm looking at Kanye West's net worth. Reasonable doubt, use your common sense. Looking up Kanye West's net worth. Then he drives his brother to work, acting his normal, meaning not talking, not saying anything. He's seen by his brother, talking to himself, laughing to himself. Again, normal behavior. But what do we know now? That he's hallucinating, having internal stimuli? That's what we know now. He told us he heard the voices. They were killing voices. Mr. Alissa has not told us a lot, but one of the consistent things he's always told us is he was hearing the voices, the killing voices. He's hearing those killing voices as he gets in the car and drives to Boulder. He's hearing those killing voices as he drives into the parking lot. He's hearing those killing voices until he starts shooting. And then they stop. Dr. Torres told us that sometimes a distraction can actually stop the voices. But what I really want you to think about is what it could be to all of a sudden one day start hearing voices. And you don't know where those voices are coming from. To start hearing someone yelling and yelling and yelling and yelling in your head all day. or maybe just at night, or maybe just in the morning, or maybe just for an hour a day, or maybe just for I don't know how long. Joe, right? Yelling voices are killing voices. Kill, 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 kill. What would that be? Mr. Alissa surrenders. They've made a really, really big deal about this. And the fact that he could surrender tells you that he knew right from wrong. Well, just as much as starting shooting could stop the voices, getting shot could stop the voices. Stop where you're at in your insanity. Dr. Torres, Dr. Gray, Dr. Pillai, they all told you that people can still do things and be insane. They're not, you can't have one or you can have one without the other. We have Sergeant Bonafide. You don't want to believe anything else. Sergeant Bonafide has no skin in this game. And honestly, if he has any, it's probably the fact that he lost Officer Talley and all those community members. He's probably not thinking of helping my client. Let's be real. And what did he tell us? He only needed to spend seconds with Mr. Alissa. And he knew how mentally ill he was. Then we have the hospital records. That Dr. Lamoureux told you that in the hospital records he read, they were seeing him actively hallucinate, being delusional in the hospital immediately after. And then you have Dr. Hatfield, just days later, seeing Mr. Alissa, delusional, psychotic. Nothing speculative about what was going on in Mr. Alissa's brain. There is so much evidence that tells you what was going on in Mr. Alissa's brain. And there is no way that somebody was hearing yelling, screaming, killing voices ever right. You don't just have that evidence, we have the sanity evaluation. I know I'm saying it over and over again, but it's just such an important piece of appreciating the magnitude of Mr. Alissa's schizophrenia. And why I continue to go back to it is because I appreciate what my client did. And I appreciate the difficulty you all have. And I appreciate what is being asked of you. 3 years before he was well enough to do the evaluation. We know that he's on a potent antipsychotic of last resort and still experiencing significant negative symptoms. There was 2 major limitations with their evaluation. The lack of articulation of his psychosis and his limited insight into mental illness. And this is why it's up to you. This right here. For Dr. Torres and Dr. Gray, for them to find someone insane, a seriously mentally ill person who experiences significant negative symptoms has to be the one to say he's insane. Just common sense. Reasonable doubt, common sense. Common sense. Mr. Alissa has been at the state hospital for 3 years because he is so sick. He is so mentally ill. He is put on the most potent antipsychotic and still exhibiting significant symptoms. And unless he says what they need to hear, they can't find him insane. It's not common sense. This is why the law says it's up to you. Because you can say that in itself is insane. Dr. Gray and Dr. Torres are not confident in their plan. They told you this. They said, because Mr. Alissa didn't open up to us, because Mr. Alissa was suffering from such severe negative symptoms directly contributed to his schizophrenia, they couldn't be confident in their opinion. Now, I put the J up there on purpose. It's not a typo. It's a little note to myself because Mr. Kuffner played Dr. Janofsky's videos, well, I should say clips, to Dr. Torres in an attempt, I guess, to get more confidence in her opinion. First of all, I want to start with, think about what Dr. Torres actually told you versus what Mr. Kuffner said she was telling you. And she told you there was very little difference between the two videos, except for he shared a little bit more. And if you remember during Dr. Torres's examination by Mr. Kuffner, he brought up this whole maybe these using them in front of the rest of the sentence in order to question whether or not it's real. Because you could tell that Dr. Janofsky was really pushing Mr. Alissa in a different way, right? So if he started with a maybe you shouldn't give as much weight to that sentence. If it matters to you at all, which I do not think it does, when you rewatch those videos, really look at all the maybes Mr. Alissa does, because he says them in front of everything. He's just trying to get Dr. Janofsky out of that room. He doesn't ever help himself. Ever. I mean, not in just the smallest, tiniest of ways. Dr. Gray begs him, Dr. Torres begs him, Dr. Janofsky begs him. This is really important. Just tell us. And yet he can't. Because he's so sick.
And so you made the 30-minute drive to Boulder. I'm sorry, to Boulder. Yeah. And you pulled into the King Super parking lot. Yeah. What happened next? Are you in voices? No, I don't expect you.
Those killing voices that had been screaming in his head. We don't know how long, because he can't tell us.
Ask a question before as well. First of all, you know, we've asked, like you said, the voices are what caused or resulted in you conducting a mass shooting. You said that's just what came to your head from their yelling. Can you think more about that?
We did the second voices, maybe like the
What's that?
second voices.
Consistent voices made me commit the mass shooting. Now, Dr. Torres and Dr. Gray told you this wasn't enough for them. For the rules and regulations that they have to follow to find someone insane, it's not enough. Those are not the rules and regulations you're under when you're considering whether or not you could know right from wrong.
Were any of these actions intended to stop the voices?
So, yeah,
What's that?
so, yeah.
You say more?
Maybe when the mass shooting, the voice on the way.
What made you think that?
I thought when the voice wanted the mass shooting.
Was it that you thought if you committed a mass shooting, then the voices might stop yelling at you because you had done what you thought they had wanted?
Dr. Ply has spent 3 years with Mr. Alissa at CMHIP. And he told you throughout those 3 years, Mr. Alissa doesn't talk much. You're never gonna have a conversation with him like you and I are gonna have a conversation. So when you look at these videos and the strain on Mr. Alissa to get anything out, and you heard about the frustration that Dr. Gray and Dr. Torres were having. This is a seriously mentally ill person. All he had to say is, yeah, I was hearing voices. Yeah, the voices told me to commit the mass shooting. The voices were telling me, go to the King Supers. The voices were telling me to kill all these people. He'd been at the state hospital receiving treatment, individualized treatment, for a long period of time. You have to believe the treatment is to help him get better, right? And yet he can't do it because he's so sick. And he can tell you, it was the voices. It was the killing voices, the consistent killing voices. It's why he bought the guns. It's why he went to the King Supers. And it's why he did this. And because of those voices, he didn't. We know that further because Dr. Gray and Dr. Torres told us even more. They diagnosed him with schizophrenia. They said that he's had it for several years. There is evidence to support that at the time of the shooting, he was in the throes of a psychotic episode. It is possible that his thinking was clouded and even confused by the symptoms, including auditory hallucinations at the time of the shooting. And it was far more likely that the shooting would never have occurred unless it was for his schizophrenia. These are things they were able to tell you. They told you, Dr. Gray told you every single one of these. It's where I ended on my cross with him. Because I was entrusting you to think about someone like this and realize they could never know right from wrong. They're clearly insane. And just because Dr. Gray and Dr. Torres are non-confident in their opinion of sanity, Mr. Alissa is not. Reasonable doubt, we've talked about this a lot. It's very, very important. Would cause people to hesitate and act in matters of importance to them. I want to go through the prosecution's case a little bit with you on things that should definitely cause you to hesitate. It was hard. It was really hard to watch victim after victim into this trial, take the stand, and tell you what happened that day. And then to listen to the police officers who were just as much victims tell you what they went through losing one of their own. They didn't bring in one victim or one police officer. Over and over and over again. Think about that. Why in the world, Mr. Edwards, Mr. Johnson, Mr. Edwards was with his mom as he's running out. He broke down on the stand. What did that add? Except for trauma to him. Mr. Johnson, who told you he's spent years in treatment trying to work through this? Why did we have to? Why? We told you our client did this intentionally. This is a question of whether or not he knew right from wrong. Mr. Edwards or Mr. Johnson or any of those others give you any information about whether he knew right from wrong? No, they haven't even argued that. They've argued that was all for intent. That was all for intent. Well, you know what it really was for? The scary. For you to hate my client. For you to have so much sympathy for these poor people that drug through this court, so that you will not look at the reality of what was going on and let the sympathy overcome you and just vote guilty. But again, we chose you because we believed you when you told us you wouldn't do that. We knew that was going to happen. Don't lose the oath in each other. What else? One could maybe get behind having to watch that video once. Maybe. 3 days. 3 days. You had to endure that trauma of watching it over and over and over again to prove intent. We're not arguing intent here. We told you that day one. Why would they do that? Why, piece by piece, over and over? We take it up, we put it down, we put Cantu on, we take her off, we put her on, we put her off. Why? To prolong the trauma, to prolong the tragedy. That's why they didn't need to do that. They are hoping what I know is not going to happen because we've entrusted you to follow your oath. They're hoping all you think about is that video. Mr. Kuffner just threatened to show the video again? Come on. Think about it. Really, really think about it. If they thought they had such a slam dunk case that there was no evidence, which they've repeatedly said, there is no evidence that he knew right from wrong. Why are we re-victimizing victims? Why are we watching a video for over 3 days? What is the point of that except to try to invoke your sympathies so you say he's guilty? To dissuade you from the real evidence of how sick he was. To dissuade you from the real evidence of the people who actually met with him, who saw him that day, and told you he couldn't have known right from wrong. Trajectory, do we even need to talk about trajectory analysis? Pathologists, how many times they were shot? Mr. Kuffner sat up here over and over, victim by victim. It's horrific. I know that. I've never denied to you what Mr. Alissa did. I've never denied to you how terrible it is. He said, how many times he shot someone? Nothing to do whether or not he was right from wrong. And you know that because they haven't even argued it. Intent. Bomb-making materials. Come on. Really? Would scare the heck out of me to know a seriously mentally ill person had bomb-making materials. But does that tell you anything about whether or not he knew right from wrong? Again, you know it doesn't because they never argued it did. They argued it went to intent. Well, we're already past that. Let's move on. The plan. Talk about the plan for a minute. The reality is a plan cannot be real unless you have a place to do it. Now, I'm not saying Mr. Alissa wasn't looking at guns. I'm not saying Mr. Alissa didn't purchase guns, but this tells us insanity. This tells you he could never have known right from wrong because it was completely random. There was zero evidence of why the King Soopers was picked. He told you that. Detective Sears told you that. There was nothing. We know this is insanity because there was 2 King Soopers right by him. And for some reason, he drives to Boulder, somewhere no connection to whatsoever. None. And he comes here. There was nothing on his phone to tie him to that King Soopers. Which tells you it was the killing voices. The loud, killing voices. Again, we're talking about reasonable doubt and things that can cause you to hesitate. Well, think about their inconsistent and illogical themes. Use your common sense. First, almost the first words out of Mr. Doherty's mouth during opening. Mr. Alissa went there to kill as many people as he could. That's why he went there. He wanted to kill as many people as he could. Problems? Well, let's talk about the problems. Angela Peacock tells us, I couldn't believe he didn't just start spraying. You saw the picture of where she was standing. She was right up front. She was right next to Denny. She was right there, wearing that big yellow bright jacket. If Mr. Alissa's intent was to go and kill as many people as he could, why did he not shoot Angela Peacock? Mr. Mala, you just saw in Mr. Kuffner's closing, Mr. Alissa just walks right past him. He's sitting right there. If his intent is to kill everyone, why is Mr. Mala alive? Paul Reuter, they're trying to spin this, that Mr. Alissa knew right from wrong because he actively chose not to kill Paul Reuter. What about any of that video tells you anything was done rationally or with choice? What about anything about what happened at that King Soopers in those moments tells you he was processing thought and thinking and considering? But most importantly, if he's there to kill as many people as he can, why didn't he kill Paul Reuter? He didn't see him once or twice. He saw him multiple times. That's inconsistent. And it's inconsistent because Mr. Alissa was insane. And the only explanation for any of this is insanity. Clint Ponsford, I think it came to 4 times. Mr. Ponsford walking in and out. Mr. Alissa walking by, according to them, still hunting for people. And he doesn't kill him. That tells you he knew right from wrong, that he was making conscious decisions. Well, that doesn't make sense if, according to their theory, he wants to kill as many people as he can. Or common sense, logical wise, Screaming voices are going on in your head, killing voices are going on in your head. You got no idea what you're doing. Well, that theme theory doesn't work too well, so let's change it up. He only went after the people saw with fear, saw running. That's how they spiced up to try to explain Mr. Roeder and Mr. Johnson that, well, we can explain he knew right from wrong because they weren't running, they weren't scared. Their whole theme is Mr. Alissa went to the King Soopers to commit a mass shooting. I don't know why you keep people alive, but even this doesn't make any sense. We know that. Doesn't Evan Stanship sick? He wasn't running. He didn't show any fear. He's sitting in his van, and Mr. Alissa killed him. If you're only looking for people who are showing fear, if you're only looking for people who are running, insanity. That's what happened. Insanity. The unprovoked and absolutely unnecessary attacks of Mr. Alissa's family. You were here, you witnessed what Mr. Doherty did to these people who were just trying to come in and tell you about their observations. Help you, quote, do what's right. And what does he do? Goes after Mustafa Alissa because he has an interpreter? Really? I thought it was 2024, and what are we doing? But I know you speak English. He was standing right there. What is that doing? Accusing them of not appreciating the extent of Mr. Alissa's mental illness. His mom, she's a homemaker, she's at home, so she should know every package that comes in for all of her sons. How dare she not? Mustafa was in possession illegally and has a felony conviction from 20 years ago for being in possession of baby formula. What's that telling us about Mr. Alissa's ability to tell right from wrong? The audacity to insinuate they should have done something to prevent this from happening. Perfect. You saw the emotion amongst all of them of the devastation this has caused them as they think of the victims and what their loved one did. And they would have done anything if they would have had any idea this could have happened. They were just trying to tell you what they knew. And he blames them. Doesn't get stopped there though. I had to really think about why we would accuse them of bias being lying, which Mr. Doherty attempted at length, which was never actually proven. Yet they don't care because they've never visited him. You never went and visited him. You never wrote him. What are we doing? Why are we doing that? If there's no evidence that my client didn't know right from wrong, why are we doing this? What is the purpose? Except to distract you. Not appreciating whatsoever how the hierarchy of the Alissa family works. The movie thing, I mean, really? That just actually verified exactly what Mahmoud was trying to tell you, which was my brother was off. My brother was different. Something was going on. And yet we're accusing him of making that comparison. And then the most frustrating thing of it all is to attack them over and over and over again Because 2 days after this shooting happened, 2 days after their son and their brother killed 10 innocent people and almost killed so many others, everything did come out of their mouth, according to him. They didn't share every single thought about how he was doing at work or how he was sleeping or every observation they noticed. They failed to do that. So clearly, what? What is that telling you? When they told you, they were in shock, understandably so. When they told you, they gave their phones, their computers, anything and everything the FBI and law enforcement wanted, they gave. I'm sorry I don't remember everything from 3.5 years ago. I'm sorry I may have not said everything. My brother was crazy. My brother was sick. My brother was not right. My son was not right. But yet we disparaged them. Common sense. What causes you to hesitate? If he has to go after them in that way, I think he's concerned that it's not clear to everyone. Mr. Alissa was so sick he didn't know right from wrong. The fuck you and this is so fun. This is so fun. Mr. Kuffner spent a lot of time yelling and screaming this. So this Mr. Graham, he was checking out. He was with the ramen noodles, and Miss Chen was in the pharmacy. Now, I'm not saying that neither one of them don't truly believe they heard Mr. Alissa say this. I am not saying they are liars. Not at all. One can only imagine what your brain must have to do to try to deal with the trauma of what they had to experience. But what you know, and why it goes back to what the family told you, what all the doctors who've worked with Mr. Alissa told you, what the sanity evaluation told you, is this did not happen. Because Mr. Alissa never showed or shows any emotion. And what's even starker about all of this is showing a range of emotions. Fuck you is an anger, right? If you're yelling that and saying that, anger is the emotion that comes to my mind. This is fun. This is so much fun. That's enjoyment. So they're basing their case on Mr. Alissa knowing right and wrong by allegedly saying two things that show huge emotions from someone who never shows an emotion at all, hasn't shown an emotion for years, and not just to his family, but to every doctor that's ever been with him. You've seen many clips of the sanity eval. Dr. Pillai told you, no emotions. But randomly on this one day, Mr. Alissa is angry and happy. Again, I don't doubt they believe it happened. But nobody else heard fuck you. And nobody else heard this is fun. This is so much fun. People who were right next to them never heard it. It's their brain trying to work through the trauma, trying to get an explanation. The one thing this case doesn't have. They're trying to figure it out for themselves. And that's okay. You just can't. Go on. The attacks on schizophrenia. I just listed some that came to mind. I'm sure you have thought of many more, but. Oh yeah, we agree. He has schizophrenia. Yeah, we agree. It's not that big of a deal. Really? I mean, and the arguments that were attempted to be made of the fact that Mr. Alissa isn't that sick, come on. So we already talked about how he attacked the family. Goes after the fact that Mr. Alissa has had no prior treatment. He's sleeping normally. He's eating normally. He's working at the family restaurant. Come on. Every family member tried to explain that, yes, Ahmad worked at the restaurant, but he's our brother. We got him through it. And Mr. Doherty went over and over and over and calling him a chef. Come on. The isolation, trying to blame the isolation at the jail somehow is Mr. Alissa knowing right from wrong, or Mr. Alissa not really being that isolated. There's nothing to support that. Refusing to talk, right? Refusing to cooperate more fully with the evaluation. We know that's a negative symptom, yet they're attacking it. Why? Oh, he registered for college. He must be sane. Let's just forget about all the other evidence that tells you he's insane. He cooked dinner. Again, nobody said this, but according to Mr. Doherty, that tells us he's sane. He knew right from wrong. And then the thing, if nothing else tells you how illogical and inconsistent their whole case is. Agent Hebrard. He is the agent who went and got the surveillance videos from across the street, where you could see Mr. Alissa putting the gun bag in the car. Remember who he is? Mr. Doherty. Well, you couldn't see his eyes darting anywhere. He asked that question. He asked that question. And then you see the video. You can't see Mr. Alissa's eyes in the video. But yeah, Agent people, yeah. Why are you doing this? If you have such a strong case that there is so much, he knew right from wrong. He wasn't that sick. He knew right from wrong. We know he knew right from wrong. When all they've shown you is intent, which is only one prong. If you are so convinced, why are we doing this? And then my favorite one of all, trying to say somehow Mr. Dunn and I are telling our client not to talk to the evaluators. In what logical realm of any world does that make any sense? I mean, honestly, just use your tongue. And over and over and over again, Mr. Doherty did it over and over. And you could see me get frustrated that I objected. What are we talking about here? Really? My client, who's accused of 55 counts, 10 counts of first-degree murder, multiple counts of attempted murder. We are running not guilty by reason of insanity. The key to that would be a sanity evaluation that says he's insane, yet I'm telling him not to talk to him. That's what I'm doing. Mr. Dunn is telling him not to talk. Now, jury instruction number 33. This goes to the idea of insanity of when, right? And this is really important because it tells you it can be temporary in nature. And again, let's not get distracted. So, well, he said 3 years later, he knew right from wrong. He understands the law. That's enough. First of all, that's not the law. Dr. Gray told you that. But most importantly, took 3 years of treatment, 3 years of meeting with a therapist to get him to be capable of doing the evaluation. And then when he's finally able to do the evaluation, he says, well, yeah, I knew it was wrong. That doesn't tell you anything. Claiming he went there to be killed. Well, that's why I went there. That was my intention. What does that really tell you about anything? And look at it in the context of he ultimately surrenders. If his intent was to be killed, but he ultimately surrenders, that tells you craziness is going on in his brain. Insanity is going on in his brain. Oh, but wait, yes, that's right. He followed commands. That's why we know he was sane, right? He followed those commands. Well, a couple things here. We talked about this earlier. After he was shot is when everything changed. After there was this drastic change in things, there was something else to focus on, maybe something else to stop what's going on in the head. That's when it happens. But I'm going to turn you back to Sergeant Bonafide, who saw him right then and there. Over 20 years of law enforcement experience, seeing victims, seeing witnesses, seeing suspects, telling them he's mentally ill. He was so calm. It was disturbing. The adrenaline rush. Well, part of the adrenaline rush comes from the this is fun, which I've already argued to you why I don't believe that is true. If you really listen to what Mr. Alissa tells you, and this is corroborated through what Dr. Torres told you, is he's talking about anxiety as adrenaline, not the adrenaline, oh, hi, this, you know, I'm so excited to kill people. He's talking about these anxiety from his killing voices. That's the context of what we're hearing about it. But most importantly, Dr. Torres told you this didn't mean it. It was only their hired gun, Dr. Lamoureux, who made anything of it. Again, they tried to insinuate, and they continue to try to insinuate somehow by killing Officer Talley that he clearly knew right from wrong. Dr. Torres said in her analysis, no. He was reacting to the movement. And what we have learned is we have no idea what was going on in his head because it was so insane at the time, because he's letting some people live and killing others. Reasonable doubt, going back to it, because you get to consider the lack of evidence. Now, they don't have to prove motive, but you get to consider the fact that there isn't one. And that the only true motive in this case is insanity. 35,000, I think, was the amount of discovery pages. We had the phone with over 6,000 images. All the testimony and evidence we've heard over the last 3 weeks. Nothing in the discovery, nothing in the phone, and not one thing from any witness that can tell you nothing. The phone in and of itself tells you this isn't it. 6,000 images of guns, weapons, you name it, it was on there, right? We saw it. Nothing about it. And that is just as much evidence as it is anything else in this case. You get to consider that just as much when you think about those killing voices screaming and yelling in Mr. Alissa's head over and over and over again. So I want to talk about rebuttal in a couple different ways. First, so rebuttal, right? Rebut the evidence we brought on. They bring you Dr. Lamoureux. What did Dr. Lamoureux tell us? He got paid $150,000 by the prosecution. What does that tell you? Huh, if there's no evidence that my client didn't know right from wrong, why do you got to spend $150,000 in less than 6 months of work? Most of us don't make that in a year. What are you talking about? But the best part about what $150,000 does for you, schizophrenia can go away. That's what he told you. According to Dr. Lamoureux, for $150,000, schizophrenia is curable. And how do we know that? because he said the most asinine, absurd thing ever. Mr. Alissa was in partial readmission. What are you talking about? Dr. Gray, Dr. Torres, Dr. Ply, Dr. Westmoreland. What did they all tell you? Schizophrenia is chronic. It lasts forever. It never goes away. But this guy, for $150,000, by the time Mr. Alissa was doing his sanity evaluation, he's almost cured. The greed of the notoriety of this guy. This is who they bring in to try and convince you that my client knew right from wrong. Someone who posts when he's visiting with clients at jails, and not just posting it, posting derogatory things about the client, talking about how he wants to be on being involved in any high profile case. That's what he cares about, is being on a high profile case. He has a $10,000 refundable retainer. Why in the world would you need a refundable retainer if you're unbiased? Well, if you don't get what you want, you get your money back, right? And then it takes the prosecution. They pay him $150,000. It's a pure distraction. That's all it is. It's a pure distraction from the real evidence in this case. He never met with Mr. Alissa. Didn't spend 1 minute with him. But yet, according to Dr. Lamoureux, Mr. Alissa is in remission. The people who've met with my client, who have spent time with my client, who know my client, have all said how sick he was, that he was suffering from psychosis on March 22nd of 2001, and absolutely it could have played a role in what happened that day. And they bring you him. Oh, as I know Mr. Doherty's getting up after me. He reviewed all the evidence in the case. I'm really glad he was able to review all the warrants in this case so he could tell you that Mr. Alissa is in range. I mean, just common sense, hesitate. The other piece of the rebuttal I want to talk to you about is when I sit down, Mr. Doherty gets to come up here and argue again. And I'm going to envision he's going to have a nice PowerPoint and talk to you again at length about the intent that my client had, that we've talked about at length, that we're not disputing. Claim again that there's no evidence, he didn't know right from wrong, but we can see there's ample evidence, and they just consistently tried to distract you. But then what I envision him doing is pointing at my client, and pointing at him, and pointing at him, and saying, that guy bought the guns. That guy was on his phone. That guy did this. That guy did that. That guy, seriously mentally ill. That guy suffering from psychosis when he killed those 10 people. That guy did not know right from wrong. I want to go back for just a minute. Mr. Dunn talked with you all during jury selection about how it's an individual decision that you get to make when you're deliberating. You'll deliberate together, but it's very important you each make your own personal decision. And when I was thinking about this, I thought, geez, you put 12 strangers together in a room, how difficult it would be to come to a conclusion just generally. But I can only imagine the difficulties of when we're talking about something to this magnitude. So I just want to remind you that you can each have your own reason for why Mr. Alissa is insane. You don't have to agree on what evidence tells you he didn't know right from wrong. It can be 12 different things for 12 different people. But what's going to be important is that if you do differ with someone else or disagree with someone else, because of the emotions I can only imagine going on during this time, that you respect each other. That you, if you have a quiet voice, make sure that quiet voice is heard. And if you're someone who has a louder voice, you're making sure that those quieter voices are being heard. Because it's essential that any verdict must reflect the personal decision of each juror. I started by telling you, finding Mr. Alissa not guilty by reason of insanity is finding him accountable. You were not saying he didn't kill those 10 people. You were not saying he didn't almost kill many, many more. But what we know is that this tragedy was born out of illness, not out of choice. Mr. Alissa committed these crimes because he was psychotic and delusional. On March 22nd of 2021, he was suffering from psychosis and delusions. That guy, he's not guilty by reason of insanity.
As I indicated earlier, we're going to take another break and that'll be for 15 minutes. And then I imagine when you come back, will be for about an hour and a half, maybe an hour and 45 minutes, because it includes reading the verdict forms that you do not have. When you do come back, I will need you to know your juror number again. It will be something that comes up in terms of juror numbers. So please know your juror number when you come back. With that, then, I'm just going to remind you of the admonition. I read it to you in its entirety at the last break, and it still applies for this break and for any other breaks. And I'll see you back here at 12:15. All right, please be seated. Mr. Dougherty, whenever you're ready, and I think you're at 60 minutes.
Thank you.
Good afternoon. Much of what the defendant just argued in their closing is belied and contradicted completely by the planning and preparation and the timeline. So you probably kept waiting for them to address what the defendant was doing from January through February through March. And if you were, you're still waiting. Because from January, February through March, he's planning, he's practicing, and he's preparing. What the defendant just argued in their closing is contradicted by all of this. You're almost done with this trial. Over the weekend, you might think, I'm going to make plans with my kids. I'm going to buy tickets to go to a game. I'm going to purchase something online. I deserve it after this trial. Picture Miss Harold yelling at you and screaming at you in the way she just portrayed the defendant's voices in his head. And you ask yourself if you could book that trip, if you could buy that thing, if you could carry through with that plan. He was making plans through January, February, and March that make his intent so clear and demonstrate that he was sane on March 22nd. Because everything he planned to do, he carried out on March 22nd. He's researching prior mass shootings. He's looking at Christchurch Mosque. He's looking at El Paso Walmart. He's looking at a mass shooting in Oklahoma. And he's buying things and he's getting ready to carry it out. And he's also typing up these notes in his phone. Exhibit 353. These notes he's modifying all the way through March 17th of 2021. And the timeline there matters a lot. Because as he's getting further into the notes, he's writing stuff about AR stuff. Bring optics to eye, not the opposite. And he's scripting out what he's going to do. He's writing this in his phone before going and killing 10 people at King Soopers. This note is last modified on March 17th. And I'm going to talk to you about what he does on March 17th, March 21st, and March 22nd. It's what the defense doesn't want you to focus on, which is the timeline, the planning, and the preparation. So it's all completely consistent with what he did on March 22nd at King Soopers. And completely contradicts what was just argued to you. He talks about how to clear a hallway. And you see on the video him doing exactly that after law enforcement gets there, looking down the aisles before he steps out. He's practiced this, he's ready for it, he trained for it, and then he carries it out just as he had planned to do. And at the same time he's doing all these things and getting ready to commit a mass shooting and practicing for it, as he told the doctors, he's making purchases of guns, ammo, and chemicals. The defense argues that bomb-making materials have nothing to do with this case. The reason you heard about them is because they reflect his state of mind. And they reflect the preparation that he put into it and his determination to kill people on March 22nd. March 22nd didn't just happen in a vacuum. He had built for this, he planned for it, it's what he wanted to carry out. He's also functioning in his daily life. He's paying his bills. He's going to the gun stores and completing all the forms. They're in evidence. They're all filled out accurately. Every box is filled out appropriately by the defendant. He's driving to work and he's dropping others off at the restaurant. And he's working as a cook at a restaurant. And that actually matters because you're here to determine if the defendant could form the intent and could distinguish between right and wrong. So the fact that he has arguably the most important job in the whole restaurant, they don't move him to busboy, they don't say be a waiter for a while, they don't say seat people, they say you do the one thing. In fact, if I asked you, ladies and gentlemen, would you be a waiter? You'd probably say yes. I said, could you do the work of a busboy? Yes. Could you do the work of a host? Sure. I just have to walk people to the table. Could you cook? Some of you would say, probably not. Not for a busy, popular restaurant. They have him in that position because he's good at it. As they tell the investigators who go to interview them time and time again after he kills all these people. And this entire time he's preparing and practicing for mass shooting. And I do want to address some of the information we learned from the defense calling the defendant's family members to testify as witnesses, as they did time and time and time again. But before I address the family, what I want to say about their testimony, it's important to put it into context. Because really, it's the forensic psychiatrist who lay the foundation for us to talk about what the family provides. Because doctors Torres, Ray, and Lamoureux all determine that the defendant is sane on March 22nd. And for each one, there's no evidence whatsoever to the contrary. Doctors Hatfield, Westmoreland, and Adi are called by the defense to testify. None of them were asked to do a sanity evaluation of this defendant. They've all done sanity evaluations in the past. Every expert in this case, every objective, ethical expert who examines the evidence will find the defendant sane. Every single one. So then it falls to the defendant's family to claim and to testify that the defendant was insane at the time of the shooting. It falls to them. That's his family. And by falls, I mean a couple things. They don't have a single expert to say the defendant was insane at the time.
Objection,
Please.
burden shifting.
Sustained.
These family members have to take the stand and say he was insane, that he was incapable of distinguishing right from wrong. And as one of his brothers said, and he's absolutely right, I'm no doctor. I can't tell you. He's 100% accurate when he says that on the stand. He's no doctor. He can't tell you. The doctors do what you do. The doctors apply the same rules that you have to.
Objection, misstatement of the law.
Sustained.
Doctors look at the sanity statute and they look at, can someone form the requisite mental state, the intent, and can someone distinguish between right and wrong? It's the exact same standard.
Overruled.
That-
Overruled, I'm sorry.
It's okay. Thank you. It's the exact same standard you're going to have. In the defendant's closing, they said the doctors use their rules. It's the same standard that you have. And ultimately, you have to decide. But it's the exact same approach. And the doctors bring their expertise. And they do everything they can in evaluating everything that happened before, during the shooting, and after, and concluding that there's no evidence whatsoever to support the idea that the defendant was insane. But in the face of overwhelming evidence, that's the defense that, as Ms. Harold said, they're running. That's the defense they were. So it falls to the defendant's family to claim the defendant was insane. So the defendant's family members testify. And I'm not going to spend much time on this, but at trial, they try to help him, as many people would do to a family member or for a family member, and they try to help their family. And how do they do that? What that means is if they could tell you he was insane back then, this ends better for him and better for them. Because instead of feeling some sense of responsibility or some fault or saying, wow, our family member just killed 10 people, they could say, you know what? He had no control over what he was doing.
Facts not into evidence.
Overruled.
So they take the stand and time again, they get caught in telling different stories than they told law enforcement back then. In long, multiple interviews, time and time again. But they're a caring family. They clearly care about one another. That is pretty obvious. They care about him enough that if they actually thought he was insane back then, they never would have let him have an assault rifle in his possession, a handgun, Mercedes, their kids, the restaurant. They gave him all of those things because they knew, although he had mental health issues, he was fully functioning during that entire time period. He was going to work and working. He was paying bills. He was making himself meals, making meals for others. He was living his life. He had mental health issues. We told you that from the very beginning. But now they come here to testify. And where they really get tripped up is around the guns. So I want to talk about that for a second. Because you saw that time and time again in their testimony. And here's why it's important. Because they take the stand and they turn and they look right at you. They look you in the face and they say, I swear, I swear, I swear, I never knew that he had a gun. The reason they say that in that moment It's because they know if they're going to convince you that they thought he was insane, they can say he had a gun. They make them look like they were responsible, and they're not. He was fully responsible. And then I would say, didn't you tell the FBI that he had guns? Oh, yes. Didn't you say he was practicing shooting? Yes. This happened with every single family member. Because they're trying to help him today. And they're trying to help their family today. And on one hand, you may be frustrated they didn't tell the truth under oath. On the other hand, you may find it makes some sense. But either way, what they told the investigators back then was true, which was he was having some mental health issues, but he was completely functional. That's why they let him have the assault rifle, the handgun, the Mercedes, the kids, the responsibility that he had in his life. But their testimony actually makes your job much easier. Because but for the fact that the defense called them to testify, you wouldn't know the following. And it's going to make your job easier. First, the father and the brothers also believed they were being followed by the FBI. So you hear this time and time again from the defense and the defense witnesses that the defendant was insane because he thought he was being followed by the FBI. The brothers and the father tell the doctor from the state hospital the exact same thing. They also believe and believed that they were being followed by the FBI during the same time period. They also tell you that on March 21st, the day before the mass shooting, he worked a full shift with no issue and no problem. He didn't call for help. He didn't have any struggles. There was no issues with the meals, nothing that anybody could remember or talk about. He worked a regular day. He had a regular shift. He took lunch at his usual time. We'll come back to his lunch break and what he did on his phone during the lunch break. His brother called him for help with a cooking recipe that day. And they had a conversation about making fava beans and how you do that. They had a whole long phone call. We also know from the family that on the night of March 21st, he's playing with his nieces and nephews at the house. He's talking to his sister. He's acting normal. He's getting dessert and then going back for seconds. This was him the night before. You now know this from the family because when they talked to the investigators back after it happened, in the days and weeks and months that followed during the investigation, they were interviewed multiple times. This is what they told the investigators. They also explained that on March 22nd, he had breakfast with his parents. He seemed completely normal, although quiet and withdrawn in the way that we've already discussed. Nothing seemed out of the ordinary. He drives his brother to work with no problem and no issue. I'll come back to that in a second. And he also tells none of them where he's going that day, what he's doing. He knows exactly what he's doing. And it's what he had planned to do, and what he prepared to do, when he purchased things to do in the months leading up to killing 10 people at King Soopers. When his brother testified, his brother said he was incapable of making any decision that day. Which is why when I asked the brother, but you let him drive your Mercedes and drive you to work. And the brother said, I don't know. I'm not so sure about that. Because obviously that makes no sense. But when confronted with the statements that he made to the investigator, he says, all right, I let him drive. I say, well, he drove on the right side of the road, right? I'm not so sure about that. Like, are you saying he drove on the wrong side of the road? Well, I don't know. Because he knows what you know, which is if you honestly had a family member who was incapable of making decisions, you're not putting him behind the wheel of the car, letting him drive you to work, and then have your car for the rest of the day. He's obeying all the traffic laws. So the defense wants you to believe that on the morning of March 22nd, even though he's obeying the traffic laws, driving without an issue, driving his brother and then being entrusted with the family Mercedes, that just a short few minutes later, he was completely insane when he's at King Soopers. The family members help you develop this timeline and understand what's going on with the defendant. They also tell you that the defendant was responsible for his actions. That's what they tell the investigators in 2021. And that he knew it was wrong to kill, as they told the investigators when they interviewed. We talk a lot about sanity in this case. The family members knew after it happened that he was responsible. They also recognized and told law enforcement that he knew not to kill, that killing is wrong. That is why it's important. That's why the family breaks off contact with him. He commits a mass shooting. He devastates an entire community. He traumatizes so many people. And the family breaks off all contact. Think about what it would take for you to break off contact with the family for 3.5 years. If you honestly believe the family member was completely insane and not responsible, you would reach out, you'd send a letter, you'd go visit. They do none of those things because they know, as the doctors determined, and as you now know, that he was fully responsible for what he did on March 26th. That's why they break off contact. That's why it's important, because it's completely consistent with what they told the investigators. He knew what he was doing. He knew it was wrong. He was functioning in the days and weeks leading up to it. That's how he's able to arm himself, prepare, and practice. As he told the doctors, I'm still practicing through February to get ready for March, to get ready to carry this out. So the family members, they come in and they testify on behalf of the defendant. The defense calls them to testify. And they say things that are completely contradicted by prior statements. But they're trying to cope and they're trying to understand why their loved one did this. And I think that's a very human thing. So should they be confronted with their prior statements? Of course. Should they lie under oath? No. But do we get it? Perhaps on some human level. But most importantly, we fill in the timeline for you and tell you that he was fully functioning during this time. That's also helped by the fact that when he leaves his house that day, he goes and carries out the mission he planned. So he drives and obeys all the traffic laws all along the way. Just as someone who is sane does and would do. He carries out his exact steps. And here I have just some quotes from some of the people who see him that day. And think about how he was described. Think about how he acted while he was carrying out the shooting. Jesse Brown, head down, on a mission, obviously firing guns. We talked about this is such fun. Daniel Slay, aiming, not random shooting. Point, aim, shoot. Allison Sheets, the doctor. He was hunting. He had a calm expression on his face. Jennifer Jacobson, focused, determined, calm, unemotional. Angela Peacock, he is determined. He is focused. Multiple shots at the victims. In the defense closing, they say, why does that matter? It matters a lot when you're trying to figure out someone's state of mind. That anybody who was targeted was shot until they were put down. It matters. You're being asked to determine his state of mind and whether he was sane. So does the fact that he focuses on people and then shoots them repeatedly until they're absolutely dead matter? Of course it does. Then we have Logan's 911 call, where it's so clear he's not spraying the store.
911 look at a spear emergency. Hi, I'm at the Turtle Mesa Kings Broadway in Turtle Mesa. Was that fire? Right there? There?
He is methodical and he is brutal. And he's carrying out the plan exactly as he practiced and exactly as he prepped for. This case, in a lot of ways, is going to come down to your common sense and your life experience, and that's why you're here. So we know through the investigation that he researched mass shootings and how to carry them out, that he then started to prepare for them. He looked at 9,000 items on his phone, 9,000 items to use. He purchased things after shopping for them, guns, ammo, chemicals. He planned, he practiced. Then he commits the mass shooting and then he surrenders to law enforcement, which does matter. Because it shows you that he recognizes that what he has done is wrong. They are there for him and they are taking him into custody because of what he has done. So the interactions with, the ambush of Officer Talley, Capobianco, and Gignac matters in determining that he understood the difference between right and wrong. And then when the second wave of officers comes in and he ambushes them, It's the difference between wrong and right. And when he ultimately surrenders without any confusion or any question, so defense counsel and zealously advocating for her client stood up here and screamed at you in the way that she wanted you to believe his screaming voices were. Ask yourself while he's hearing those voices, if that's the way he does, did he actually follow SWAT team's directions as clearly as he did, without any delay, without any confusion, without any hesitation? The answer is no. He knows that they're there for him and he's able to follow their commands and without any delay at all. And in the face of overwhelming evidence and expert testimony, the defendant now asks you to consider the very things you're instructed not to. The defendant wants you to consider the very things you're actually instructed not to consider, because the evidence in this case is overwhelming, and every expert agrees that he was sinning. So they ask you, think about the why. Think about where he should be sent next. Think about his current mental health. Each one of those things, you're actually not supposed to consider. So first, the why. By the time we get done with Judge Bafi's instructions and the verdict forms, it'll be 142 pages that are read to you. 142 because of how many people he killed and tried to kill. 142 pages. You want to know how many times the word why appears? That's 0. That's actually 0. So when they stand up here and say, think about why, it's because the evidence is overwhelming. That's actually a question that we never have to answer as prosecutors in any criminal case, murder or otherwise. The why. It's never required. Go through the charges, go through the list of elements, that list. You'll never see the word why. Defense asks you to consider whether he belongs in a hospital. And that last slide that they had up there was the same slide from their opening, hospital or a cage. And they want you to think about that. You're not supposed to think about it. You're not supposed to consider it. You're not supposed to let it influence your decision. The law specifically tells you not to, actually. So why is the defense asking you to consider things that you're not supposed to consider? You're not supposed to consider this. The judge gave you an instruction. This is the top half of it. It goes on, and you have it. It's instruction 35. And it talks about what the process is for someone who's been found not guilty by reason of insanity. This serves an important purpose, which is juries should make decisions based on evidence. They should know that someone's not getting out tomorrow if they're found not guilty by reason of insanity, and that there's a process. They should know those things. But they're also not to consider it at all. That's the very first line of that instruction. Don't let this have any persuasive bearing on your evaluation of the evidence. This instruction is so that juries could know you should find him not guilty by reason of insanity if that's what the evidence demands and requires. And don't worry about when he's getting out. But the instruction, if you read it, also explains the process. And it explains that when Ms. Harold says in the defense closing, and when they said it in their opening, he's there indefinitely, that is not true. There's a process for people to be released. That's what that instruction explains. The juries aren't left wondering. The law is written that way, so you're not left speculating about that. And you can make the right decision in this case based on why each of you were chosen, which was each one of you said when you were picked as jurors in this case. Each one of you said, I just want to follow the law. I'm going to apply the law to the evidence. I just want to reach the right outcome. Each one of you said that. That's why you're here. And in the face of overwhelming evidence and in the face of the law that the judge gives you, the defense asks you to consider things that you're not supposed to consider. If you were actually supposed to consider, does he belong in a cage, as they say, or the hospital, you would have a bunch of questions. You would say, what's the staffing situation at the state hospital? If we're taking on this decision, we're a group that cares a lot. We clearly are, by the way. And we're a smart group of people. We want to know, what's the staffing situation at the hospital? Because when Dr. Bly testified, they actually had 0 doctors there for 8 months. Is that still going on before we say where he should go? You would ask, how do mental health facilities and prisons compare to the state hospital? Because both Dr. Westmoreland and Dr. Hatfield have worked in mental health facilities within state prisons. Dr. Westmoreland said the sad reality is that some of those are better than any community resource that we have. in the state of Colorado, the ones that she's worked at in prisons. You'd want to know a lot more about this if this decision was actually entrusted to you. You would ask, can individuals ever be transferred from a state prison to the state hospital? You would say, how many individuals actually petition for release each year? What's the number of people who go through this process? What is the complete process? What's the average length of stay? And when will this defendant be released? So the defense gets up in their closing and they say he will be there indefinitely. That is not true. And as the prosecutor, I could get up and I could say, you know what? In 3.5 years, these people might be screaming because they're going to see on TV that he's getting released. But that's not right either. All I'm going to ask you to do is just follow the law. I'm not going to try to scare you with this or talk about what possibilities there are. I'm just going to say follow the law. And if you have any doubt about what the law requires, I'm going to ask you to look to Judge Bakke. And I'm going to ask you to look at instruction number 1. The first instruction she just read to you, it's in your packet. If you decide that the prosecution has proved beyond a reasonable doubt the defendant is guilty and that you're saying it'll be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. So I stand here right now and I just ask you, reach the right decision based on the evidence and follow the law. Don't consider things you're not supposed to. Just follow the evidence and apply the law and do the right thing based on the evidence and what it demands. And as Judge Bakke said, consider all your experiences in life in evaluating the evidence. We'll come back to that. But ask yourself, why does the defendant argue so strongly in their closing to consider the 3 things you're not supposed to consider? The evidence in this case is overwhelming. And the experts all agree. Yes, he has schizophrenia. Millions of people do. Schizophrenia doesn't mean someone's insane. When they apply the test under the law that you've been instructed on, and look at all the planning and the preparation and how he carried it out, it was clear to the doctors that he was sane on March 22nd, 2021. Defendant argues insanity is the only explanation for this mass shooting. It's the only reason someone would commit a mass shooting. Again, that's not true. That's not true. Mass shootings, by the very nature of them, are extremely abnormal. You might be thinking, I wish they were more abnormal. But when someone commits a mass shooting, it doesn't render them automatically insane under the law. You know this. You apply the legal test to determine whether someone's actually insane or not. Think about what the defendant's arguing here implicitly. That someone kills one person, guy stabs his girlfriend to death, bring him to the Justice Center, we'll try the case in this room. We have a drive-by gang shooting, we'll try it in the courtroom right down the hallway. But kill 10 people at King Soopers, kill 23 at Walmart, kill 51 at 2 different mosques, kill 26 at an elementary school. And by the very nature of what you've done, you're just going straight to the state hospital. That evidence response team for the FBI, where you have people from all around the country who respond and go to places like Mandalay Bay in Vegas, Uvalde, Boulder. Let's shut that down. Because from now on mass shootings, we're just sending people to the state hospital because it must just be insanity. It's certainly crazy. But it doesn't mean someone's legally insane. When this defendant gunned down 10 people at King Soopers and tried to kill so many others, if a community member heard the news, you would probably think, this is so crazy. I can't believe this happened in Boulder. And that person would be right. But legally insane is something altogether different. We're going to talk more about that. But insanity is not the only explanation for mass shooting. That cannot and should not be the law. In fact, it's not the law. Based on the crime someone commits, we don't immediately determine whether they're guilty or not. We also don't immediately attribute it to some mental health condition or not. We apply the test. The test includes this quote that Judge Bakke read to you. That care should be taken not to confuse mental disease or defect, and it goes on. And it goes on to explain, because people are still accountable to the law, And that's why you apply the legal test around sanity. So he's sane on March 22nd, 2021. And I want to talk about what happens next, because I do think it's very important for what you're about to do. He's arrested. He follows every direction that day and the next. Then he's interviewed at the jail. First Boulder County Jail, then he's moved to Broomfield County Jail. And they ask him at the medical screening, do you hear voices? He says, rarely. They said, well, do the voices tell you to harm yourself or others? No, they don't. This is March 23rd, 2021. Dr. Westmoreland says his first few months in the jail, he's sufficiently engaged, he promptly answers questions, he has appropriate eye contact, and his movements were fluid. In other words, he was moving normally. This is Dr. Westmoreland watching the video from the sheriff's deputies who work there and wear body-worn cameras. Dr. Hatfield notes in his records, April 7th, no evidence of psychosis. April 9th, no evidence of psychosis. April 13th, no evidence of psychosis. April 17th, no evidence of psychosis. May 7th, mental status stable, but could not assess more per the defense terms. I want to be really clear about this for a moment. This is not something I create or that I say. These are the doctors writing it in their reports. And as Dr. Hatfield talked about on cross, the reason it matters is when you have someone suffering from the negative symptoms of schizophrenia, you want to try to assess how much of that is due to illness and how much of it is due to them being told, do not speak with him. Someday, it might be used against you in a court of laws. Keep your mouth shut, even with the mental health professionals, at the jail, and then later at the state hospital. Do not speak. So the doctors and the medical staff, they write this in their reports. They put it in there because they're trying to figure out which of this is a symptom, which of this is volition. We know just from our own life experience that when someone's isolated, it exacerbates issues, especially mental illness. So if I said to you, starting tomorrow, are you going to be at the Boulder County Jail by yourself in a cell for 9 months? What do you think the impact's going to be on this? Think about it. What are the impacts going to be? And then what are the impacts for someone suffering from mental illness? By his choice, he's completely isolated during that time. The defense team came up with Dr. Hatfield. It's really stunning, actually. Ordered that he not receive medication after arriving at the jail. The defense team ordered that the defendant not receive any medication. Dr. Hatfield explained that maybe for the first month, that'd be appropriate because you want to determine if someone's going through method-induced psychosis. So that's from March 23rd. Dr. Westmoreland examines him in November. He still has received no medication. And he's in a cell, 5-bin cell. That entire time. The reason it matters is because he deteriorates. When you try to look at the timeline and figure out when does he start to get worse, look at Dr. Westwood, who's called as a defense witness. And she's an expert. She's great at her job. She says he deteriorated a lot. Because when it goes untreated, which was their direction and demand, it gets worse. So that decline matters. And I want to explain really clearly why that decline matters. Because you now have to figure out, was he sane on March 22nd? So when Dr. Westmoreland meets with him on November 9th and November 19th, looks at the video from early on in his stay at the jail and sees a significant decline, it's due to the fact that he's being isolated and not being medicated at all. He's in a cell by himself 24/7. He's not receiving any medicine because they refuse to let him. March 22nd, he is sane. And then he gets worse. And it's not a surprise to the defense experts, Dr. Westmore, Dr. Hatfield.
Objection, arguing facts not into evidence. Neither of those doctors said that he was sane at the time.
So what I will let folks know is you are to rely on your recollection of the evidence and not what either counsel or any of the three counsel have argued to you. It's what you remember the evidence to be.
And just to be clear, it's true, Dr. Westmoreland and Dr. Hatfield were not asked to examine the defendant's status. Every expert who was asked found the defendant safe. But Dr. Westmoreland and Dr. Hatfield agreed isolation makes things worse. Lack of medication makes things worse. Dr. Hatfield said to you, you'll remember this too. Dr. Hatfield said to you, under my ethical code, I have to make sure someone gets medication when they need it. Do you remember him saying that? And it's refused. It is refused. It only matters in terms of the decline. That's the only reason it matters for you. Because what you don't have to consider or answer are these questions. What do you make of the decisions to isolate? You do not need to talk about that or answer it. What do you make of the decisions to block him from mental health professionals and to not let him talk with them? Do not answer that. You don't have to. What do you think about the fact that they refuse to allow him to get medication? You don't have to consider that. You don't have to answer that. How can the state hospital, switch into the state hospital for a second, have literally no doctors on their treatment staff for a period of 8 months? Dr. Pillai leaves in July to go do his fellowship. And I would submit to you that he seems like an earnest, hardworking professional who's just starting out in his career, and he cares. But then he's gone because he has to do the fellowship up in Denver. And from July of 2022 through March of 2023, Dr. Pillai shares with you, there's not a single doctor at the state hospital for the state of Colorado. No doctor there on a treatment team for the defendant. None. And Dr. Pillai testified, you know what? It doesn't really matter because it's all about the medication. You don't need to answer, is that how we want a state hospital to be run? That people just get medicated and they're sitting in their room? Because before Dr. Pillai left, there was 40 minutes of direct treatment per week, 40 minutes per week. I imagine that if you have a relative in the hospital and you go and you say, Dad, how are they treating you here? He said, you know what? They don't have any doctors, but people check in on me about 20 minutes per week. You'd probably say, we need to go. You can't stay here. You don't need to answer the question about what was the impact on this defendant and on other patients during that time period. That's not a question for you to answer or consider. Nor do you have to answer, why did this case take so long? You might look at the first question and the second question and think, that might be part of the reason this case took so long. That when the family members were asking, what's the status of the criminal case? That if someone were saying to them, he's at the state hospital, and the family member said, well, what are the doctors saying? And the response was, there actually are no doctors. No one was there as a doctor. There are other medical professionals there, the nurses and nurse practitioners who play important roles. But they're just putting the medicine to these people and to the defendant. Why did this case take so long? Is not a question you have to answer. And it should not impact your review of the evidence. But certainly, the time had come to end this case. And there's just one question left, which is, could he distinguish between right and wrong? That is the last question. That's the only question. The defense now concedes that the defendant was able to form the intent. So it's the only question. And when you look at his actions and everything he did in the planning, preparation, the timeline, and what he did at King Soopers, the answer is yes. He hid his prep and his intentions from his family because he knew what we know from hearing from them. They would all think what he was doing was wrong. His realization that they knew it was wrong reflects that he also knew it was wrong. If you have a kid in your family that you're interacting with, there's a certain point in life where kids realize, if I say this to mom or dad, I'm going to get in trouble because it's wrong. That's true when we go through our whole lives. You don't say something to a partner or to a roommate or to a colleague because you know what you're doing is wrong. And if you share it, they're going to react. That's why the defendant hides his preparation. That's why none of them knew about the bomb-making materials or the extent to which he was buying different guns and different ammunition during that time period. He goes to a King Soopers that will not impact his family because he knows what he's doing is wrong, and that's going to have a direct impact on them. You may recall one of the brothers, understandably, said, or perhaps understandably said, I've never been to the Table Mesa King Supers. Why would he ever want to go there? His brother killed 10 people there. The defendant drove by 2 different King Supers that his family uses on a regular basis, one for home and one for the restaurant. They still use to this day, they still go to King Supers. Because he knows what he's about to do is wrong and it's going to have an impact on his family. And when law enforcement arrives, he looks out the door, and for the first time in that entire video, you see him running the other way. The whole video is him charging right at people. He's zeroing in, he's focusing on them, and he's coming. He looks outside and he sees police cars with lights, and for the first time, he starts running the other way. That part of the video, that says everything you need to know about right and wrong. He knows they're there for him, which means he knows what he has done is wrong. And then he heads away from the police, and he's about to ambush them. And he ambushes them and engages them in a shootout. And you will recall that Brandon Braun thought he was shot, that he had blood coming from his face. That Sam Kilburn was close enough to the glass that glass hits his face and he's bleeding from it as well. I surrender, I'm unarmed, don't shoot, I give up. Dr. Lamoureux touched on this. Sometimes when people, with him getting shot, the defendant getting shot, changes his mind perhaps. It also could be what we all know about individuals who think that they want to take their own lives. And when the moment comes, they decide not to. Whatever it is, he decides to surrender, and he's surrendering to law enforcement. He's not trying to surrender to the people in the pharmacy. He understands exactly what's happening. He's surrendering to law enforcement. The video answers this question. Could he distinguish between right and wrong? Just watch the video. It's answered there. The defense in their closing made a lot about the video, talked a lot about it. And on one hand, we could have rolled in here 3 weeks ago and said, watch this, then I'll stand up and I'll argue for an hour and you'll find this guy guilty. But that would be a complete disservice to the victims, their families, and the job you have to do.
Sustained.
The job you have to do as jurors.
Objection
So why
to
do we-
that last statement as well, Your Honor. That it would be a disservice as jurors.
The job, I'm sorry,
Overruled as to the job you have to do as jurors in terms of if they had just done that and done nothing else. The portion as it relates to disservice to other folks is granted. I sustain the objection, and you're to disregard it.
the defense in their closing asked you why we called the victims to the stand. Because the defendant tried to kill them. And you as jurors have to decide on 55 different counts whether he's guilty. And to do your job and to do your job right and reach the right outcome, that evidence matters. That's why this video answers this question, just the video alone. But there's more. There's Dr. Gray, who finds the defendant sane and says there's no evidence to the contrary. Dr. Gray says there's no evidence of an inability to distinguish. No evidence is what Dr. Gray says. An absence of any evidence, he goes on to explain, that voices prevented him from distinguishing between right and wrong. Dr. Torres finds the defendant sane, highlighting that in the months leading up to the offense, he purchases the gun, the vest, the ammunition. He goes through all the planning while he's also working every day, was Dr. Torres's testimony. His mental illness did not impair his capacity to form mental state. He definitely has a mental illness. We've said that since the very beginning. But it did not impair his capacity to form mental state or to understand the difference between right and wrong. She goes on to explain to you, there were no voices commanding. He offered no justification whatsoever. He even said, when I was working, I would just ignore the voices. And Dr. Torres shared with you that his comments about the jail and the police highlight that he's able to distinguish between right and wrong. Then think about what he tells Dr. Hatfield at the Boulder County Jail in the summer of 2021. He wanted the death penalty to be imposed because of what he did to the victims. The defendant was upset that Colorado no longer has the death penalty. He killed people and should be put to death, what the defendant is saying. There's probably no greater sign of the defendant's understanding of right and wrong than him saying, give me the death penalty because of what I did. He knew it was wrong. Now he's asking to be punished.
And I'm gonna
Carried
object,
out.
because this is a misstatement of the law. What his thoughts were in the summer of 2021 are not relevant to whether or not he was sane on March 22nd of 2021. Sanity is at the time of the offense.
Yes, sir.
That is correct. Sanity is at the time of the offense. We spent a lot of time in the defense closing talking about everything that happened after March of 2020.
I agree. And I think all three of us now are going to remind you that you are to approach the issue of sanity at the time of the offense, but both have argued how he appeared afterward and was diagnosed afterward and how he appeared before.
That's why this matters. And we turn to Dr. Lammers, he was incredibly compelling. And the defense asked him only a couple questions about working for defense attorneys, about working for prosecutors, he works mostly for defense attorneys, and appearing on the media for different cases that he's not involved in around the country. There's no conflict there. You probably were wondering, as the questions were coming to Dr. Lamoureux, where is this going? Where does this guy go? What did he say on TV? What's on his Facebook page, besides the fact that he was saying, here I am in Las Vegas, Clark County? The answer was no. That's the same answer to you. How many questions did they actually ask him about his opinion? Dr. Lamoureux told you really clear words that the defendant was able to distinguish between wrong and right, and that the defendant could form the intent, and that the defendant is sane. And all he was asked about was media interviews that he had done on other cases where he had done nothing wrong, not a single thing. Under the law, the defense just commented in their closing that Dr. Lamoureux didn't interview the defendant. Under the law in Colorado, a prosecution expert is not permitted to interview the defendant. You heard that during his testimony. He wanted to, said cannot. And he's told the law prohibits a prosecution expert from interviewing a defendant during a sanity evaluation. Instead, he went through the entire case file and explained to you he has an obligation to be ethical and truthful. Sure. Sorry. And that if he's retained by prosecutors or defense attorneys and he can't agree with their position, he'll tell them and he will not accept the case. He told you that. That's what it means to be an ethical professional. Dr. Torres and Gray were both appointed by and worked for the court in this case. Let's talk about Dr. Janowski for a minute, because Dr. Janowski interviews the defendant. He gets more information from him. Dr. Torres looks at it and is even more confident in her determination. She makes her determination in April. Janowski interviews the defendant in June. And then Dr. Torres is able to watch those interviews. She says there are additional details. The defendant actually has a better memory than he led her to believe. No delusions whatsoever, nothing different about the voices. In other words, no commands, no justification. And Dr. Torres testifies, we didn't miss anything. And it's quite straightforward. He's sane. After she watches Janowski's video, especially clip 4, where the defendant talks about how it was wrong, that he knew it was murder and that murder was wrong, that he was practicing with his guns in February. She lands on the word straightforward and saying that he's sane. Dr. Lamoureux, it is a sad reality, ladies and gentlemen, that there's additional funding available for mass shooting cases. That actually exist, that there's a resource there that allows.
Arguing facts, not into evidence.
It was in evidence, additional
The
funding.
additional, but going further than that,
Agreed. There was no evidence sustained in that portion.
What's in evidence is that there was additional funding obtained by the district attorney's office, because this is a mass shooting case, to hire Dr. Lamoureux. So you may think the video was enough. You may have been here 2 weeks ago and thought you had me at video. Dr. Gray or Dr. Torres. But the fact of the matter is this guy killed 10 people. And you have to make a really important decision. So we used every resource to give you every piece of evidence that one would need. And you have it. So the defense gets up here and yells about $150,000. Maybe you just needed to hear from Greg, or maybe just Torres. Maybe the two of them together. But now you've also heard from Dr. Lamro, and he also finds the defendant to be sane. And he explains to you that he was in partial remission at the time of the 2024 interview, but people have schizophrenia for their entire lives. There's also no question at all, actually, that he reached the right conclusion in finding the defendant sane. What would a tougher case be for a jury here? It's this on the screen. And when you heard the defendant's theory of the case that Judge Bakke read to you this morning, this is what that tougher case would actually look like. Documented mental.
Jack, this is improper argument.
Wait a minute.
Right.
Yeah.
I think this is all fair commentary to put in perspective what the case is and what the case is not, especially given the theory of the case that the court read at the request of the defense about confusions driving the defendant to do certain things.
You can argue it from that perspective as opposed to a tougher hypothetical.
You read the defense, when you heard, you read the defense theory of the case. This is the factual scenario that comes to mind. That a defendant is making prior statements about an alien base at Safeway supermarket. That he has a documented mental health history. There's no evidence of planning or purchases. Instead, before and during the shooting, he's acting impulsively, and he appears to be reacting to hallucinations and delusions and voices. And at the time of his arrest, he tries to hug the police officers because they're all on the same side. And the defendant tells the doctors, I had to do it. I was trying to save Earth. And then one or two of the experts find the defendant to have been insane on that day. And the trial becomes a battle of experts. None of these things are in this case. None. Every doctor who conducted a sanity evaluation found the defendant to be sane. There's no evidence whatsoever to support not guilty by reason of insanity. If you follow the evidence and apply the law, you will reach the right outcome. You were here because the defendant planned, prepared, and then carried out a mass shooting. And the defendant has chosen to exercise his constitutional right to a fair trial. And from looking at you over the last few weeks, you've been very committed to doing exactly that, making sure he had a fair trial. If you follow the evidence and apply the law, you will reach the right outcome. Don't do it because of emotions. Counsel accused us of trying to play to emotions and scare you, finding him guilty. If we were doing that, we would have presented baby photos of each victim and pictures of them playing with family members. That's actually not what the prosecution in this case has done. We were trying to play with your emotions. We put in hundreds of photos from the crime scene, the autopsy, 3 more days of video evidence. You haven't seen the body-worn camera recordings from any other officer who was there, other than on that one master clip, that one. You'd have additional testimony from all the people hiding throughout the store, over 100. All of them would be listed as victims of attempted murder, extreme indifference. We'd have King Soopers testify as to the damage and the cost. You'd hear from family members who lost their loved ones to someone who was saying it was fun. Their shopping lists were in their pocket. You'd learn what Terry Leiker had in their pocket when she was working at King Soopers and was killed. You would learn what Suzanne Fountain had in her pocket. You would learn what they had, what they were looking for when they went to King Soopers, each one of the customers. We didn't do that. Instead, we focused on the defense.
Objection, Your Honor, to this slide in reference to my client.
You want to respond to that?
Sure.
And
Counsel,
You want to approach?
yes, and I asked that the slide be taken down until the court's made a ruling.
Please do. Yes. 1-8. Can you help her with a chair? Do you need a chair? And we'll get it, Robin.
I don't know if I'll be able to hear you if I get a chair.
Okay. The objection is sustained. And Mr. Dougherty, I will let you know when you have approximately 3 minutes left.
Instead of showing you the shopping list that the victims had in their pockets that day, he showed you the shopping list the defendant had. And you look at what he did in the days and weeks and months leading up to this. The guns, the ammo, the chemicals, day after day after day after day. This goes on. It goes on and on. Those pictures, these are in evidence. You'll be able to look at each one. This is what the defendant was doing. This is what he was putting together. He's on his phone. He's looking at Boulder. This is from March 18th, 2021. He's looking at these locations. This is March 21st during his lunch break from the restaurant. So he's on lunch break. He's looking at Target, Whole Foods, Safeway, Plato's, Safeway. Petco. David Whitman. The victims on March 21st? They were probably thinking about their day of work on Monday, the next day. They were probably asking their loved ones.
Objection, Your Honor, improper argument.
Overruled.
What do you need from King Soopers? I'm going there tomorrow. The people who went to Safeway, Petco, Target, they live. People who go to King Soopers have their lives forever altered. You're gonna give me a 3-minute warning, so?
Actually, you have 4 minutes starting now.
You haven't been able to talk to your loved ones about this case since the start. When one describes this case, it's fair to say it's horrific and it's hard. And it's also straightforward. Started in January. Does the shopping, practicing, he targets Boulder. He kills 10 innocent people with brutal precision. The video, as Mr. Kuffner said, you will never forget. And he clearly had mental health issues then and now. But every expert agrees that he was sane on March 22nd, 2021. It's a hard case. That's how one might describe it when you talk to your family about it. But there were some real unsung heroes from that day too. Christopher Tatum, who goes back in the store 4 times. Logan Smith, who sees the shooter go in and he realizes, I need to go back in. And for the police officers, there are some officers who probably would say, don't ever call me a hero, it's my job. They did their job that day. And for Eric Talley, he gave up his life doing his job. And for the 7 kids he leaves behind, yes, they know that he died, saving so many others. But at the end of the day, they just don't have what they have. Jury has given him a fair trial. That's clear. Follow the evidence, you apply the law, and you reach the right outcome. In the defense closing, Ms. Harold said, there's no words. There's no words to address this tragedy. There's one word that the evidence demands. It's overwhelming evidence and expert testimony. And it is horrific beyond words. From the very beginning, you've paid careful attention. And in your jury questionnaire, you may have said, I want to know exactly what happened, because I think that sometimes people who claim not guilty by reason of insanity might just be using it to avoid responsibility. You may have written that in the questionnaire. All the evidence has been provided. We've also been very direct from the beginning that he has schizophrenia. Evidence is overwhelming. Don't reach the decision that he's guilty based on an emotional reaction. Reach that decision as the evidence demands and requires.
All right, the final instruction, and I didn't go through the instructions number by number for you. That was my mistake, but we're at instruction 39. The bailiff will now escort you to the jury room where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree on according to the rules that I am about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. Only one verdict shall be returned signed for each count. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 55 verdict forms. When you have unanimously agreed upon your verdict, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. I will now read to you the verdict forms. You must not draw any inferences based on the order in which I read them. The verdict forms you will receive read as follows. Jury verdict, count number 1 as to Nevin Stanich, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count 1, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa, excuse me, not guilty by reason of insanity of count number 1, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 1, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then one above should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict of guilty murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 2, Kevin Mahoney, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 2, murder in the first degree. Signature line of the foreperson. Counsel, do you waive reporting of this section as well? It is on the FTR.
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count 2, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 2, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 3, Trolana Bartoluk, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 3, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 3, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 3, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. The verdict is not guilty, then Roman 1 should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 4, Ricky Olds, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 4, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 4, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 4, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. The verdict is not guilty, then Roman 1 should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 5, Dennis Stong, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 5, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 5, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 5, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then Roman 1 should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 6, Lynn Murray, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 6, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 6, murder in the first degree. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 6, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 7, Terry Leiker, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 7, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 7, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 7, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 8, Jody Waters, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 8, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 8, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 8, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 9, Suzanne Fountain, murder in the first degree. We the jury, Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 9, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 9, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 9, murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 10, Eric Talley, murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 10, murder in the first degree, signature line. Roman 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count 10, murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 10, murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then Roman 1 above should be signed. If the verdict is not guilty by reason of insanity, then Roman 2 above should be signed. If the verdict is guilty, murder in the first degree, then Roman 3 above should be signed. Jury verdict, count number 11, Angela Peacock, extreme indifference, attempt to commit murder in the first degree. Roman 1, we the jury find the defendant Ahmad Alissa not guilty of count number 11, attempt to commit murder in the first degree, signature line. Roman 2, we, the jury, find the defendant, Ahmad Alissa, not guilty by reason of insanity of count 11, attempt to commit murder in the first degree, signature line. Roman 3, we, the jury, find the defendant, Ahmad Alissa, guilty of count number 11, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. There are 2 boxes for you to check, yes or no signature line. Jury verdict, count number 12, Casey Taylor, extreme indifference, attempt to commit murder in the first degree. Roman 1, we the jury find the defendant, Ahmad Alissa, not guilty of count number 12, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant, Ahmad Alissa, not guilty by reason of insanity of count number 12, attempt to commit murder in the first degree, signature line. Roman 3, we the jury find the defendant, Ahmad Alissa, guilty of count number 12, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. The verdict is not guilty by reason of insanity, then 2 above should be signed. The verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, then you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. There's box yes, box no, and signature line. Jury verdict count number 13, Hayden Steele, extreme indifference, attempt to commit murder in the first degree. Roman 1, we the jury find the defendant, Ahmad Alissa, not guilty of count number 13, attempt to commit murder in the first degree, signature line. Roman 2, we the jury find the defendant, Ahmad Alissa, not guilty by reason of insanity of count number 13, attempt to commit murder in the first degree, signature line. Roman 3, we the jury find the defendant, Ahmad Alissa, guilty of count number 13, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder of the first degree, then Roman 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Box for yes, box for no, and a signature line. Jury verdict count number 14, Kajendra Mala, extreme indifference, attempt to commit murder in the first degree. Roman 1, we the jury find the defendant, Ahmad Al Aliwi not guilty of count number 14, attempt to commit murder in the first degree, signature line. Roman 2, we the jury find the defendant, Ahmad Al Aliwi not guilty by reason of insanity of count number 14, attempt to commit murder in the first degree, signature line. Roman 3, we the jury find the defendant, Ahmad Al Aliwi guilty of count number 14, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit murder, first-degree murder, or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, then you should mark no in the appropriate place and have the foreperson sign the designated line on the verdict form. It's a box for yes and a box for no, and then the signature line. Count number 15, Jacqueline Keaton, extreme indifference, attempt to commit murder in the first degree. Roman 1. We, the jury, find the defendant, Ahmad Al Aliwi, not guilty of count number 15, attempt to commit murder in the first degree, signature line. Number 2, we, the jury, find the defendant, Ahmad Al Aliwi, not guilty by reason of insanity of count number 15, attempt to commit murder in the first degree, signature line. Number 3, we, the jury, find the defendant, Ahmad Al Aliwi, guilty of count number 15, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then number 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then number 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit murder, first degree, or in the immediate flight therefrom, deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all of the evidence, if you decide the prosecution has failed to meet this burden, then you should mark no in the appropriate place. Have the foreperson sign the designated line of the verdict form. There's a box for yes, box for no, and signature line. Jury verdict, count number 16, Paul Johnson, extreme indifference, attempt to commit murder in the first degree. Number 1, we the jury find the defendant, Ahmad Alissa, not guilty of count number 16, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant, Ahmad Alissa, not guilty by reason of insanity of count number 16, attempt to commit murder in the first degree, signature line. Number 3, we the jury find the defendant, Ahmad Alissa, guilty of count number 16, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then one above should be signed. If the verdict is not guilty by reason of insanity, then number 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon, yes or no? The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you will mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and then a signature line. Jury verdict, count number 17, Kimberly Breckus, extreme indifference, attempt to commit murder in the first degree. Number 1, we the jury find the defendant, Ahmad Alissa, not guilty of count number 17, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant, Ahmad Alissa, not guilty by reason of insanity of count number 17, attempt to commit murder in the first degree, signature line. Number 3, we the jury find the defendant, Ahmad Alissa, guilty of count number 17, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then one above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit first-degree murder or the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and then signature line. Jury verdict, count number 18, Michael Hong, extreme indifference, attempt to commit murder in the first degree. Number 1, we the jury find the defendant, Ahmad Alissa, not guilty of count 18, attempt to commit murder in the first degree, signature line. Number two, we, the jury, find the defendant, Ahmad Al Alissa, not guilty by reason of insanity of count number 18, attempt to commit murder in the first degree, signature line. Number three, we, the jury, find the defendant, Ahmad Al Alissa, guilty of count number 18, attempt to commit murder in the first degree, signature line. The foreperson should sign only one above, 1, 2, or 3. If the verdict is not guilty, then one above should be signed. The verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number one, the defendant used or possessed and threatened the use of a deadly weapon. Number two, during the commission of attempt to commit murder in the first degree or the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line on the verdict form, box for yes, box for no, and then a signature line. Jury verdict, count number 19. Tasia Beresford, extreme indifference, attempt to commit murder in the first degree. Roman 1, we the jury find the defendant, Ahmad Al Alissa, not guilty of count number 19, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant, Ahmad Al Alissa, not guilty by reason of insanity of count number 19, attempt to commit murder in the first degree, signature line. Roman 3, we the jury find the defendant, Ahmad Al Alissa, guilty of count number 19, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number 1, the defendant used or possessed and threatened the use of a deadly weapon. Number 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all of the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and the signature line. Jury verdict, count number 20. Patrick Cruz, extreme indifference, attempt to commit murder in the first degree. Number 1, we the jury find the defendant, Ahmad Al Alissa, not guilty of count number 20, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant, Ahmad Al Alissa, not guilty by reason of insanity of count number 20, attempt to commit murder in the first degree, signature line. Number 3, we the jury find the defendant, Ahmad Al Alissa, guilty of count number 20, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then number 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty. and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number one, the defendant used or possessed and threatened the use of a deadly weapon. Number two, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and a signature line for the foreperson. Jury verdict count number 21, James Graham, extreme indifference, attempt to commit murder in the first degree. Number one, we the jury find the defendant Ahmad Al Aliwi and not guilty of count number 21, attempt to commit murder in the first degree, signature line. Number two, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 21, attempt to commit murder in the first degree, signature line. Number three, we the jury find the defendant Ahmad Al Aliwi guilty of count number 21, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then one above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, number one, the defendant used or possessed and threatened the use of a deadly weapon, and two, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and a signature line. Jury verdict, count number 22, Kelly Ray Dorr, extreme indifference, attempt to commit murder in the first degree. One, we the jury find the defendant Ahmad Al Aliwi not guilty of count 22, attempt to commit murder in the first degree, signature line. Number two, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 22, attempt to commit murder in the first degree, signature line. Number three, we the jury find the defendant Ahmad Al Aliwi guilty of count number 22, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. The verdict is not guilty by reason of insanity, then 2 above should be signed. The verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Box for yes, box for no, and a signature line for the foreperson. All right, jury verdict, count number 23, Sarah Moonshadow, after deliberation, attempt to commit murder in the first degree. Number one, we the jury find the defendant Ahmad Alissa not guilty of count number 23, attempt to commit murder in the first degree, signature line. Number two, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 23, attempt to commit murder in the first degree, signature line. Number three, we the jury find the defendant Ahmad Alissa guilty of count number 23, attempt to commit murder in the first degree. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then one above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, 1, the defendant used or possessed and threatened the use of a deadly weapon, and number 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. It's that box for yes, box for no, and then the signature line. Jury verdict, count number 24, Sarah Moonshadow, extreme indifference, attempt to commit murder in the first degree. Number 1, we the jury find the defendant Ahmad Alissa not guilty of count number 24, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count 24, attempt to commit murder in the first degree, signature line. Number 3, we the jury find the defendant Ahmad Alissa guilty of count number 24, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Yes, no, and then the signature line. Jury verdict count number 25, Nick Edwards, after deliberation, attempt to commit murder in the first degree. Number 1, we the jury find the defendant Ahmad Alissa not guilty of count number 25, attempt to commit murder in the first degree, signature line. Number 2, we the jury find the defendant Ahmad Alissa not guilty by reason of insanity of count number 25, attempt to commit murder in the first degree, signature line. Roman 3, we the jury find the defendant Ahmad Alissa guilty of count number 25, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, Roman 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree. You should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, one, the defendant used or possessed and threatened the use of a deadly weapon, two, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, a box for yes, a box for no, and then the signature line. Jury verdict count number 26, Nick Edwards, extreme indifference, attempt to commit murder in the first degree. One, we, the jury, find the defendant, Ahmad Al Aliwi Alissa, not guilty of count number 26, attempt to commit murder in the first degree, signature line. Number two, we, the jury, find the defendant, Ahmad Al Aliwi Alissa, not guilty by reason of insanity of count number 26, attempt to commit murder in the first degree, signature line. Number three, we, the jury, find the defendant, Ahmad Al Aliwi Alissa, guilty of count number 26, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then one above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all of the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. It's a box for yes, box for no, and then the signature line. Jury verdict count number 27, Christopher Tatum, after deliberation, attempt to commit murder in the first degree. Count number Roman 1. We, the jury, find the defendant, Ahmad Al Aliwi Alissa, not guilty of count number 27, attempt to commit murder in the first degree, signature line. Number 2, we, the jury, find the defendant, Ahmad Al Aliwi Alissa, not guilty by reason of insanity of count number 27, attempt to commit murder in the first degree, signature line. Roman 3, we, the jury, find the defendant, Ahmad Al Aliwi Alissa, guilty of count number 27, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if, 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and then the signature line. Count number 28 is to Christopher Tatum, extreme indifference, attempt to commit murder in the first degree. One, we, the jury, find the defendant Ahmad Alissa not guilty of count number 28, attempt to commit murder in the first degree, signature line. Two, we, the jury, find the defendant Ahmad Alissa not guilty by reason of insanity of count number 28, attempt to commit murder in the first degree, signature line. Number three, we, the jury, find the defendant Ahmad Alissa guilty of count number 28, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line on the verdict form, box for yes, box for no, and a signature line. Jury verdict, count number 29, Brian Capobianco, extreme indifference, attempt to commit murder in the first degree. 1, we, the jury, find the defendant Ahmad Alissa not guilty of count number 29, attempt to commit murder in the first degree, signature line. 2, we, the jury, find the defendant Ahmad Alissa not guilty by reason of insanity, count 29, attempt to commit murder in the first degree, signature line. 3, we, the jury, find the defendant Ahmad Alissa guilty of count number 29, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit murder in the first degree or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each number condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. It's a box for yes and box for no, and then that signature line. Jury verdict, count number 30, Pam Gignac, extreme indifference, attempt to commit murder in the first degree. Number 1, we, the jury, find the defendant Ahmad Alissa not guilty of count number 30, attempt to commit murder in the first degree, signature line. Number 2, we, the jury, find the defendant Ahmad Alissa not guilty by reason of insanity of count number 30, attempt to commit first degree murder, signature line. Number 3, we, the jury, find the defendant Ahmad Alissa guilty of count number 30, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of attempt to commit first-degree murder or in the immediate flight therefrom. Deadly weapon is defined as a firearm, whether loaded or unloaded. The prosecution has the burden to prove each numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Box for yes, box for no, and then the signature line. Jury verdict, count number 31, Richard Stidel, after deliberation, attempt to commit murder in the first degree. 1, we, the jury, find the defendant Ahmad Al Alissa not guilty of count number 31, attempt to commit murder in the first degree, signature line. Number 2, we, the jury, find the defendant Ahmad Al Alissa not guilty by reason of insanity of count number 31, attempt to commit murder in the first degree, signature line. Number 3, we, the jury, find the defendant Ahmad Al Alissa guilty of count number 31, attempt to commit murder in the first degree, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, attempt to commit murder in the first degree, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of attempt to commit murder in the first degree, you should disregard this instruction. If, however, you find the defendant guilty of attempt to commit murder in the first degree, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer yes or no. If the defendant used or possessed and threatened the use of a deadly assault in the first degree, then 3 above should be signed. Jury verdict, count number 50, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant Ahmad Al Alissa not guilty of count number 50, possession of a large capacity magazine during the commission of a felony, signature line. 2, we, the jury, find the defendant Ahmad Al Alissa not guilty by reason of insanity of count 50, possession of a large capacity magazine during the commission of a felony, signature line. 3, we, the jury, find the defendant Ahmad Al Alissa guilty of count number 50, possession of a large capacity magazine during the commission of a felony, signature line. The foreperson should sign only 1 above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty possession of a large capacity magazine during the commission of a felony, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of possession of a large capacity magazine during the commission of a felony, you should disregard this instruction. If, however, you find the defendant guilty of possession of a large capacity magazine during the commission of a felony, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the defendant possess the large capacity magazine during commission of a specified crime? Answer yes or no. The defendant possessed the large capacity magazine during the commission of a specified crime only if 1, the defendant possessed a large capacity magazine during the commission of murder in the first degree as defined in your instructions. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. There's a box for yes, a box for no, and then the signature line. Jury verdict, count number 51, possession of a large capacity magazine during the commission of a felony. Number 1, we, the jury, find the defendant Ahmad Al Alissa not guilty of count number 51, possession of a large capacity magazine during commission of a felony, signature line. 2, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 51, possession of a large capacity magazine during the commission of a felony, signature line. 3, we the jury find the defendant Ahmad Al Aliwi guilty of count number 51, possession of a large capacity magazine during the commission of a felony, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. The verdict is guilty possession of a large capacity magazine during the commission of a felony, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of possession of a large capacity magazine during the commission of a felony, you should disregard this instruction. If, however, you find the defendant guilty of possession of a large capacity magazine during the commission of a felony, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the defendant possess the large capacity magazine during the commission of a specified crime? Answer yes or no. The defendant possessed the large capacity magazine during the commission of a specified crime only if 1, the defendant possessed a large capacity magazine during the commission of murder in the first degree, as defined in your instructions. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all of the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Box for yes, box for no, and then a signature line. Jury verdict count number 52, possession of a large capacity magazine during the commission of a felony. 1, we the jury find the defendant Ahmad Al Aliwi not guilty of count number 52, possession of a large capacity magazine during the commission of a felony, signature line. 2, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 52, possession of a large capacity magazine during the commission of a felony, signature line. 3, we the jury find the defendant Ahmad Al Aliwi guilty of count number 52, possession of a large capacity magazine during the commission of a felony, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty, possession of a large capacity magazine during the commission of a felony, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of possession of a large capacity magazine during the commission of a felony, you should disregard this instruction. If, however, you find the defendant guilty of possession of a large capacity magazine during the commission of a felony, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the defendant possess the large capacity magazine during the commission of a specified crime? Answer yes or no. The defendant possessed the large capacity magazine during the commission of a specified crime only if 1, the defendant possessed a large capacity magazine during the commission of murder in the first degree as defined in your instructions. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Box for yes, box for no, and then a signature line for the foreperson. Jury verdict, count number 53, possession of a large capacity magazine during the commission of a felony. Number 1, we the jury find the defendant Ahmad Al Aliwi not guilty of count number 53, possession of a large capacity magazine during the commission of a felony, signature line. 2, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 53, possession of a large capacity magazine during the commission of a felony, signature line. 3, we the jury find the defendant Ahmad Al Aliwi guilty of count number 53, possession of a large capacity magazine during the commission of a felony, signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty possession of a large capacity magazine during the commission of a felony, then 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of possession of a large capacity magazine during the commission of a felony, you should disregard this instruction. If, however, you find the defendant guilty of possession of a large capacity magazine during the commission of a felony, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the defendant possess the large capacity magazine during commission of a specified crime? Answer yes or no. The defendant possessed the large capacity magazine during the commission of a specified crime only if, one, the defendant possessed a large capacity magazine during the commission of murder in the first degree as defined in your instructions. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all of the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Box for yes, box for no, and then the signature line. Jury verdict count number 54, possession of a large capacity magazine during the commission of a felony. Number 1, we the jury find the defendant Ahmad Al Aliwi not guilty of count number 54, possession of a large capacity magazine during the commission of a felony. Signature line. 2, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 54, possession of a large capacity magazine during the commission of a felony. Signature line. 3, we the jury find the defendant Ahmad Al Aliwi guilty of count number 54, possession of a large capacity magazine during the commission of a felony. Signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty possession of a large capacity magazine during the commission of a felony, 3 above should be signed. If you find the defendant not guilty or not guilty by reason of insanity of a possession of a large capacity magazine during the commission of a felony, you should disregard this instruction. If, however, you find the defendant guilty of possession of a large capacity magazine during the commission of a felony, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the defendant possess the large capacity magazine during the commission of a specified crime? Answer yes or no. The defendant possessed the large capacity magazine during the commission of a specified crime only if, 1, the defendant possessed a large capacity magazine during the commission of murder in the first degree as defined in your instructions. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes at the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form, box for yes, box for no, and a signature line. Jury verdict count number 55, possession of a large capacity magazine during the commission of a felony. Number 1, we the jury find the defendant Ahmad Al Aliwi not guilty of count number 55, possession of a large capacity magazine during the commission of a felony. Signature line. 2, we the jury find the defendant Ahmad Al Aliwi not guilty by reason of insanity of count number 55, possession of a large capacity magazine during the commission of a felony. Signature line. 3, we the jury find the defendant Ahmad Al Aliwi guilty of count number 55, possession of a large capacity magazine during the commission of a felony. Signature line. The foreperson should sign only one of the above, 1, 2, or 3. If the verdict is not guilty, then 1 above should be signed. If the verdict is not guilty by reason of insanity, then 2 above should be signed. If the verdict is guilty possession of a large capacity magazine during the commission of a felony, then 3 above should be signed. If you find the defendant not guilty by reason of insanity of possession of a large capacity magazine during the commission of a felony, you should disregard this instruction. If, however, you find the defendant guilty of possession of a large capacity magazine during the commission of a felony, you should sign the verdict form to indicate your finding of guilty and answer the following verdict question on the verdict form. Did the defendant possess the large capacity magazine during commission of a specified crime? Answer yes or no. The defendant possessed the large capacity magazine during the commission of a specified crime only if 1, the defendant possessed a large capacity magazine during commission of murder in the first degree as defined in your instructions. The prosecution has the burden to prove the condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes at the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. There is a box for yes and a box for no, and then the signature line. And for the record, I am reading from a notebook which is designated as People of the State of Colorado versus Alissa Ahmad Al Aliwi. Jury instructions and verdict forms to be returned to the court. So this is what you give back to me when you have reached your verdicts. With that, a few more matters. I had indicated that I need you all to be familiar with your juror number. That is because we're going to identify who the alternates are. And so if I read your number, if you would please raise your hand, 2970, you are an alternate. 4137, you are an alternate. 3058, you are an alternate. And 3744. I am not seeing a 3744, and I have that on my list.
That's who we had as well, just so the court knows.
3744,
We know who it is.
okay.
I'm not sure if we got helped anyone, but.
I'm gonna use initials, EZ. All right, you are 3744. You are an alternate. So I'm going to release the other 12 jurors. And I would like you four to remain. For you 12 jurors, a couple of things. One is that generally we can start at 9 o'clock. However, if you can all agree you want to start earlier, I am happy to start at 8 or 8:30, or we can keep it at 9. You can let me know at the end of the day. We will break each day at 5 o'clock unless you are close to a verdict and it's like 5 o'clock, then we'll stay and let you reach a verdict. If it appears that it's close, otherwise I'll have you come back. So today you'll go home at 5. Monday, you all let me know through one person or through Brian, actually through Brian, what time each day you would like to return to deliberate in that room there. You will be ordering lunch through us every day. We'll provide you lunch and breakfast as we have been thus far. If you would like to view the evidence that is on video, you need to let Brian know, and we will have you view it in here in the courtroom with nobody else present, including Brian. You will have a means to communicate with him when you are done. All right, Brian, if you will stand and raise your right hand. Do you solemnly swear under penalty of law that you will, to the utmost of your ability, keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself unless by order of the court, except to ask them if they have agreed upon a verdict, and that when they have agreed, you will return with them into court? All right. You 12 are excused. You 4 remain, please. The rest of the evidence will be brought to you. The physical evidence. And take your books. Yes, sir. Oh, and I gave you the notebook. Okay. All right, thank you. Please be seated. So for the 4 of you, your service is going to continue. It's going to be a bit different than the 12. And have you remain here until 5 when everyone is released, and have you return each day next week until a verdict is returned. You're going to be kept in a separate jury room. And the admonition that I have been reading, I will read to you again when I release you to that jury room with Brian, will apply to you. Most importantly, you're not to deliberate. You can't discuss this case amongst yourselves because you are not part of that group. But I need to have you here in case I need you. We're going into a 2-day weekend. COVID is floating around out there. People could get sick, something happens, someone passes in someone's family. And if so, under certain conditions, I would call on the alternates. You were not selected because of anything other than randomly before you were ever even seated. Okay? So it had nothing to do with how you answered questions or anything of that nature. It was designated by me randomly based on seating. Okay? So with that, when Brian gets back in here, I'm going to tell you that you're going to recess until 5 o'clock. I want to remind you that until the trial is completed and I have a verdict, you are not to discuss this case with anyone by any means. This includes your members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, let me know about it immediately. You must not read or listen to any news reports of the trial. You must not consult any outside reference materials, including a dictionary, encyclopedia, the internet. Finally, remember, it is especially important that you do not form or express any opinion on the case until it's finally submitted to you. I'm going to ask you to leave those jury instructions in the seats that you're sitting in right now because you won't be needing them. You are welcome to bring any books to read. I'm going to allow you to bring electronics. If you have an iPad or a computer that you can watch movies, some earbuds, you're welcome to do that. Just completely adhere to the admonition, but I understand it's going to be rather uncomfortable, to say the least, that you're just going to be sitting and trying to keep yourself occupied in case you're needed or until we get a verdict. With that, hopefully Brian will be here shortly. I hear him. Brian, I'm going to have you take these 4 into the other juror room.
All right.
And we'll get some lunch for you. Please rise for these jurors. Can you take the closing PowerPoint off of here and save it in the drawer?
We also need to get their stuff today.
Okay, okay, let's do that. Thank you, Brian. I forgot about that. Yeah, let's just leave everything and we'll keep those safe and confidential for you. Thank you for reminding me of that. Have a seat. So as I indicated, we'll break at 5. What I'm wondering is if I should just bring them all in here as a group and let them all go at 5, or if I should do it separately. Do either of you have a position on that?
I'm fine with the court just doing it separately, Your Honor, and just at 5.
Okay.
I'm fine to have the court release them. I just would like them to hear the admonition again. Because it's a lot to get.
It is. I understand. So I'll bring in the 12.
Okay.
I'm going to read the admonition, release them, and then I'm going to bring in the 4.
Okay.
I'll do them separately.
Okay.
That's fine. Okay, thank you. Anything? Yeah.
Sorry. Just normally, the court would tell us how long between once you receive a note indicating the verdict, how long before you want to take the verdict, just so we could let people on the victim's families know how long they could be before asking for it back when it comes.
I was thinking half an hour,
That's right.
half an hour for your. Okay, 30 minutes. All right, thank you.
And we don't have to be here at 5 o'clock then in the courtroom?
You don't have to.
Okay.
I'll just release them.
All right, thank you, Judge.
Okay.
I'll figure out this stuff. Judge. So you'll be.
Yeah, 'cause I'm gonna do the admonition.
Right.
Thank
And then
you.
they'll take you back to jail and then they're gonna
Thanks.
bring you back Monday morning. Okay, you don't have to get dressed out right away if you don't want to. Okay. Okay.
Okay. It was a very long time, but we made it, okay? Well, we'll see, okay? They can come back at any time, remember, but I would anticipate it'll be Monday again. Yep, that's what they're doing right now. Yep, they're gonna stop at 5 today. Okay, so they'll take you back to the jail at 5. Okay, so stay in your clothes until 5 o'clock. Okay, just in case you need to come upstairs. Okay? Well, I'm not, I just wanted to cover. Okay, I'm thinking about. You just do that, just because I'm 58, yes, well, that's my own. I just wanted to make sure. Yes.
Hey, man, are you able to stay here for a minute or are you got duties? Okay.
Thank you. Thanks, man. Oh, that's. Got it, Bob?
Yeah, I'm good. Thanks. Just let me know when the screen set up.
I can take all of that stuff. Wasn't me, I cussed a lot. I had to be sure. It was turned off.
Thank you.
Helping.
I know nothing.
Sam, I don't think E and F got in, right?
Correct.
Yeah, they didn't.
Did you try to bring that B? I don't know. Okay,
No, we never opted.
okay, yeah, that's what I thought.
All right.
Thank you, I appreciate
You're welcome.
that. Mary, can come learn something. We've got to go through the entire list and all of the binders and make sure it's accurate.
My WebEx might still be on. Yep.
And that includes Marion, just so you know, the physical items as well. Okay.
Remember when you said there was something that were admitted, but saw offer not admitted?
Yes.
So I took out, which I think was the only ones, but I want to double check, 328 and 332. Which actually I don't think we are.
Yeah, I'm trying to.
Uh-huh. It's not. Make sure what you.